fucking roadways. I remember that. Oh, you thought that other song was coming on. You were wrong.
Bueno, mira. Señora, ay señorita, nadie sabía lo que iba a pasar. Solamente fuiste y me dejaste solito en la eternidad. Señora, ay señorita, yo sé que ahora estás lejos de mí y siempre estoy pensando lo que estás haciendo y si te sientes más feliz, y si te sientes más feliz, oye, y espero yo que no te sientas sola y que tu vida está llena de felicidad. Porque deseo que nadie tenga que sentirse ahora mismo como yo, atrapado en la oscuridad, solito en la eternidad, solito en la eternidad, oye. Trompeta.
Pisco on the vocal.
Ahora sí, camina para allá. Saxofón con Garcia. Toca.
Guilty as charged. Had to go,
Espero yo que no te sientas sola y que tu vida está llena de felicidad. Porque deseo
But it was a happy gathering, so all worth it.
Ahora mismo como yo, atrapado en la oscuridad y solito en la eternidad.
It's freezing here, though.
Ay señora, vuélvete. Ay señora, ya se fue.
Yes, if what up, everybody? Hope you're doing well. We have some stuff to discuss today. Yeah, so I'm back home for a happy, joyous occasion. So that's all good, but it's just freezing. The train ride was nice, though. How y'all doing? You might be wondering why we got a little green guy here, because you have no idea where this stream is going, do ya? Do ya, punk? Sí, claro. What up, Taylor? What up, 13, the A-man? What up, Aquila? What up, Sharpie? Mir isn't wrong that they shouldn't have been able to grant withholding and removal without an order of removal. They're just paying for the IJ fucking up the order. Yeah, we'll talk about that momentarily. we'll talk about all that. Regardless, you have issues with the no matter what, there are mess ups that we're gonna get into. For sure, for sure. Okay. First of all, welcome everybody. Hope you guys are doing well. You guys can hear me, can't you? You can hear me, I hope. Low tech, yeah, sorry. Please excuse the background. Cool. First off, some housekeeping. Tomorrow, probably going to talk to Hutch about the Ethan Klein lawsuit. It's our 10,000th conversation about. But we didn't really get a chance to get into it and live and learn because we didn't want to spend the whole time there just talking while Soy Pill and IRI watched on from their little chairs, from the cuck chairs. So that'll happen tomorrow. Is this tacit support for Mangione? No. It's an indicator that one of the things I want to show you is the government is not only fucking up shit with Kilmar, potentially big fuck ups, potentially in the Mangione case. Oh, the light. It's blinding. So a specific part of this I want to look at is going to be the Fourth Amendment analysis, where they want to exclude memberships. Amazing memberships. Thank you so much, Vasaraka, the Chief Justice of Memberships. You should talk to Loanerbox about the client stuff too. I'm down. I saw there was a comment in one of my VODs to talk to Loanerbox about the about the Ethan Klein stuff, but then also I saw this tweet from Stardust.
As they seize control of a massive oil tanker off Venezuela's coast. Word of the mission, the surprise mission.
You didn't respond because you haven't fucking made one, you idiot. Make an argument. Tell me why it is bad to seize an oil tanker that is being used to support the IRGC, to support terrorist activity. Tell me why that's bad. Tell me why that's bad to not let these fucking organizations fund their...
As they seize...
Tell me why Trump's illegal and aggressive acts against Venezuela are bad. Yeah, I would love to talk to a loner about that and about the Ethan stuff. For sure. And then at the end of all of this, I'm going to have a compilation of all the bigger streamers or streamers at all who agree that I'm correct. So we have Connor. We have him. I'll clip that one, and then we'll get everyone to acknowledge that I'm correct. But then also about this stuff, I really, and he doesn't actually justify it there. It's more like a question, like, give me an argument why it's bad. I'm not sure why that isn't apparent to someone like Loanerbox. I think it should be apparent that it's an illegal and aggressive action that isn't justified under the circumstances, given the potential for a war, which is not in the interest of America and would be illegal under international law and under the laws of the United States. Surely that's a good enough reason to be against it. But yeah, so I would definitely be interested in talking to Loanerbox about that issue and also the Ethan Klein thing. I read a federal judge approved a seizure warrant for the tanker like 2 weeks ago. That would be weird. Wait, really? Hang on a second. I'm going to look into this. I'm going to Google. I would still be against it even if they did, for policy reasons. Federal court seizure warrant tanker. Oh. I actually need a source for that. Who said this? Tabish. Oh, they announced it, yeah. Today, the FBI, Homeland Security Investigations, and the United States Coast Guard, with support from the Department of War, executed a search warrant for a crude oil tanker used to transport sanctioned oil from Venezuela and Iran. Executed a seizure warrant. That doesn't indicate to me that it did so from a federal court. A seizure warrant. I mean, what the fuck? Where did it come from? I'm not under. I don't understand what the basis would be for a court to exercise jurisdiction in this context without some kind of like national hook here, and to authorize a seizure by the military in international waters in the high seas, absent some jurisdictional hook for a U.S. court to. I mean, which court? Let's see. According to the New York Times, a federal judge issued a seizure warrant roughly 2 weeks ago because of the ship's past activities smuggling Iranian oil, not because of links to the Maduro government. The official said prosecutors have said that Iran uses money generated from oil sales to finance its military and the Islamic Revolutionary Guard Corps, which the United States has designated as a terrorist entity. Okay. Let me go to New York Times. New York Times. Oh, I'll DM Loanerbox. New York Times. What do you call this? Tanker seizure? I have an account, you motherfuckers. Don't you ever make me log in again. I don't want to upgrade. Don't fucking... When I pay for something, don't sell me other stuff. I never want to see it. All right, let's see what it says. Let's see. Control F warrant. Miss Bondi said the tanker had been used to transport sanctioned oil from Venezuela and Iran. The U.S. agencies were acting on a warrant issued by a federal judge roughly 2 weeks ago that was based on the ship's record of smuggling Iranian oil, not because of links to the Maduro government. Yeah, I just don't understand the legal justification for the exercise of jurisdiction on the high seas like that to enforce U.S. sanctions. And I'm against it even if it were legal under U.S. law, by the way. Just heads up. But I need some sort of what's the basis here? I wish we had some fucking legal analysis. The article said they would seize more in the coming weeks. It says that Bondi alleges this. Maybe they did. Let's see. Is there more? I'm going to Google. Sorry, guys. This is boring for you. Just give me a second to do a little Googling before we get into the meat and potatoes here. Google warrant and tanker and Venezuela. I get that Boolean shit in. Tanker was falsely flying Guyana's flag, the country's maritime authority had said. The flag of a ship indicates where it has been registered, and under international law, ships must comply with the maritime law of the country when out at sea, of that country when out at sea. However, in recent years, there's been a growth in vessels sailing under false flags, allowing them to circumvent safety regulations and international sanctions. Tracking data shows that Skipper was previously sanctioned by the U.S. It was accused of belonging to the so-called Shadow Fleet, which smuggles oil on behalf of Iran in order to avoid U.S. sanctions. It had also made multiple trips to Venezuela and Iran in recent years. Public records show the vessel is owned by Triton Navigation Corporation, which was sanctioned by the United States in 2022 for its involvement in transporting oil. What was the vessel doing when it was seized? According to the marine traffic, the vessel had been transmitting a false position, a well-recorded tactic among shadow tankers that transport sanctioned Russian, Venezuelan, and Iranian oil. Despite location data putting the vessel closer to the coast of Guyana, satellite imagery shows that it was in fact in the Venezuelan port of Jose for weeks. Okay. Ship departed Venezuela last week with roughly half of its cargo of oil belonging to a Cuban state-run oil importer. Venezuelan government has said the seizure constituted blatant theft and active international piracy. Why has the U.S. seized this tanker? U.S. government has sanctioned more than 107 vessels it accuses of moving illicit oil, while the number sanctioned by other governments and organizations likely numbers more than 1,000. Experts are in disagreement over why it was singled out. In its statement, the government of Maduro, who the fuck cares, analysts have suggested that as the U.S. is the world's largest oil producer, there are other motives, whatever. The U.S. has seized sanctioned oil tankers before. Wednesday's accident is notable for the dramatic nature of the operation. Other experts have suggested that seizure of the Skipper will act as a further break. Where's the fucking warrant? Shit. Okay, now I'm going to do a deep dive. Not right now, though. I don't understand what the basis is for a court to issue a warrant, a seizure warrant, on foreign ships traveling on the high seas without some kind of hook with the U.S., involving U.S. citizens, involving U.S. bank accounts, involving U.S. something. Maybe that's there. But I also don't agree with this action at this time because I see it as ratcheting up tensions with Venezuela, and I don't agree with that, given the posture of the fleet and the potential for war. Why don't I just call in? Does he take call-ins? Okay. According to the article, they said that he's more. Okay, we were talking about that. All right. That's enough for me just speculating, but interesting. Thank you so much for bringing that to my attention, Tabish. Shout out to Kick Chatters. I know there's not many of you, mostly YouTube and Twitch, but shout out. Can you ask Lactoid if federal courts have jurisdiction to issue warrants on ships in international seas? I wish maybe I can run a search on like Lexus or something. It's gotta be. Let me run 2 more searches. One sec. There has to be a nexus with violations of U.S. law. Let's see. So what kind of violation of U.S. law are we talking about? So maybe there's a violation of U.S. sanctions, but is there jurisdiction? Because whatever law it is defining the sanctions, the scope of the sanctions, there's got to be some like extraterritoriality principles that are being applied to whatever basis that is on the legality and policy ramifications of high sea. Ooh, look at this. This is an older article, but I like it. High sea seizures of foreign merchant vessels for violating U.S. sections. All right. Sorry, I'm gonna look at this article real quick. I'll show it to you guys though, so you don't get lost. And then we'll get into my actual shit. We'll talk about the fools. We'll talk about everything. And it's an article from 2021 from Lawfare. Okay. Let's called On the Legality and Policy Ramifications of High Sea Seizures Foreign Merchant Vessels for Violating U.S. Sanctions. Despite robust U.S. sanctions, Tehran and Caracas are undertaking a significant shipping operation to provide desperately needed cash to Iran and weapons and fuel to Venezuela. The Iranian frigate Iris Sahand and converted oil tanker Irenis, whatever the fuck. The latter, freshly commissioned as a military vessel, are currently transiting the Atlantic en route to Venezuela. If these ships reach Venezuela, it will be a milestone in Iran's evolving efforts to circumvent U.S. sanctions, and it will mark a renaissance for the Cold War-era tactic of converting commercial vessels into warships to gain treaty-protected grants of sovereign immunity guaranteeing safe passage for illicit cargo aboard. The U.S. views the Iranian government as an illegitimate, anti-democratic regime whose nuclear aspirations and dreams of regional hegemony are destabilizing the Middle East. In its effort to undermine the regime and Iran's nuclear program, the U.S. has sanctioned individuals, entities, and organs of the Iranian state. No problem with me there. Frozen billions in assets, conducted targeted military strikes, well, depends on those strikes, and tacitly supported assassinations. Regarding Caracas, the United States is committed to punitively sanctioning the Maduro regime after it invalidated the 2019 election of Juan Guaido, with Venezuelan losses estimated at $30 billion and climbing. So sanctions on these regimes, that seems fine. As from a legal perspective. U.S. Department of Justice has estimated that in the spring of 2019 alone, the Islamic Revolutionary Guard Corps, the IRGC, a branch of the Iranian military, coordinated the clandestine transfer of approximately 10 million barrels of crude oil and millions more in condensate, I don't even know this fucking word, and gasoline, am I stupid, including Maduro's beleaguered regime in Caracas, netting Iran hundreds of millions of desperately needed dollars. With Iran atop a fiscal cliff, the U.S. has redoubled its sanction efforts to include seizures of Iranian fuel and weapons exports. The U.S. contends either supports international terrorism or funding Iranian state terrorism, or both. While high-profile shipping seizures are not without precedent, U.S. sanction enforcement is straining traditionally accepted state behavior in the maritime to such an extent that the U.S. is very likely operating at the limit of its sovereign authority. Iran's use of warships to deliver fuel and arms to Venezuela, a move designed to deter U.S. intervention in the transfer, represents a major escalation in the United States conflicts with both states. Thus far, the U.S.'s aggressive sanction enforcement against Iran has not violated international law of the sea, but this escalation could be disastrous in the long term. Understanding where that line is requires a brief primer on the law of the sea. Factors that affect the legality of the interdictions include the ship's claimed identity, the location of the seizure, the domestic and international authorities under which the interdiction occurs, and, especially important given facts at hand, whether the vessel is a warship. Ships transiting the high seas are subject exclusively to the jurisdiction of the state under whose flag they are sailing, a paradigm drawn from both customary and international modern treaty law. Customary international law is an amalgamation of norms, practices, and judgments that enjoy broad international acceptance. As for treaties, the two central multilateral pacts regulating state interference with foreign shipping are the 1958 Convention on the Law of the High Seas, which the United States has ratified, and the 1982 UN Convention on the Laws of the Seas. The U.S. has not ratified UNCLOS, but has accepted large portions as accurately reflecting customary international law. Okay. Both treaty and customary international law prescribe state interference with foreign flagged vessels outside exceptional circumstances, primarily the slave trade, illegal broadcasting, and piracy. In all other cases, Article 3 of the 1958 Convention and Article 94 of UNCLOS, UNCLOS, prohibit high seas interdictions of foreign vessels without pre-authorization from the vessel state. Additional rules prescribe strict limits on the search and seizure of boarded vessels. Taken holistically, the calculus suggests breaching customary law or either treaty will produce only negative long-term outcomes for the violating state by degrading international legal norms. Okay, that's not the question is, are they actually violating them? Factors affecting foreign flagged ship and cargo seizures include the domestic and or international legal justification for the seizure, the identities of the ship or cargo and of the state conducting the seizure, the nature of the cargo, and the location of the seizure. Treaty and customary law restrict seizures of foreign merchant ships to ships transiting in a state's territorial waters, with an essentially blanket ban against seizures on the high seas. Okay, that's what this was, right? Critically, both the 1958 Convention and UNCLOS afford warships sovereign immunity on the high seas. Barring a warship unlawfully using force or otherwise breaching international law, warships effectively have complete freedom of movement and action. All right, but this wasn't purporting to be a warship. Globally, UNCLOS has subsumed the 1958 Convention as the international law of the sea, though it is unratified by the United States. In the law of the sea disputes, the Supreme Court and multiple circuits hold that U.S. law incorporates UNCLOS only to the extent that it reflects customary international law. This leaves the 1958 Convention as controlling in U.S. courts. However, despite the U.S. ratification of the 1958 Convention, courts considering it must still confront whether the relevant treaty provisions are self-executing. This distinction, which has perennial fuzzy edges, is instrumental to determining whether courts have jurisdiction to hear treaty law claims. Self-executing treaty provisions are those that can operate without implementing legislation. U.S. courts generally regard such provisions as equivalent to federal statutes. Got it. So the question is whether it's self-executing. U.S. courts maintain their jurisdictional bounds are exclusively constitutional or statutory, and that customary international law is insufficient to restrict their authority on the high seas, absent Congress explicitly abdicating jurisdiction. So basically, as a matter of U.S. law, what they care about is whether or not the laws of the U.S. and of the Constitution allow them to exercise jurisdiction, not whether it violates international law, except to the extent that Congress has signed off on that. U.S. Court of Appeals for the Fifth Circuit tackled self-execution of the convention curtailing jurisdiction over foreign vessels in international waters in U.S. v. Postal, which involved a drug runner seized in the Southern Caribbean. The Postal Court found that Article 6 not to be self-executing, and therefore that it could not restrict the jurisdiction of U.S. courts. More broadly, international law defenses to U.S. jurisdiction generally fail unless the court holds the treaty provision to be truly self-executing, or the claimant can prove the court is statutorily precluded from exercising jurisdiction in their specific scenario. While courts tend to uphold the principle of restricting the extraterritorial application of U.S. law, got it, that makes sense, they are willing to distinguish applications of the protective principle, granting U.S. courts high seas jurisdiction over offenses committed in violation of U.S. criminal law. So two things are whether the U.S. law applies to these ships and whether the courts have jurisdiction over it, according to the rules of United States jurisdiction. That Postal and its progeny give the U.S. government remarkable latitude to justify extraterritorial jurisdiction on the high seas creates enormous friction with both the convention and UNCLOS. As long as the United States does not unilaterally seize ships or cargoes in another state's territorial waters or seize foreign vessels on the high seas, it has a clear domestic statutory basis for the seizures that appear consistent with domestic precedent and international legal principles as construed in U.S. courts. However, the U.S. must tread carefully in the absence of parallel multilateral sanctions against the Iranian regime. U.S. sanctions alone provide a variety of authorities through which the U.S. may seize Iranian property. Those upon which the United States relies to seize Iranian shipping includes, but are not limited to, the Iranian Transactions and Sanctions Regulations, statutory authority to seize assets of designated foreign terrorist organizations, including the IRGC, and the Iran and Libya Sanctions Act of 1996, as incorporated in the International Emergency Economic Powers Act. IEPA is also at issue, by the way, folks, in the tariff situations. In 2010, Congress amended the 1996 Sanctions Act to specifically ratchet sanctions on Iran's petroleum industry. As for Venezuela, U.S. sanctions against the Maduro regime largely target the financial sector. Beyond sanctions, Congress has empowered U.S. law enforcement and courts to effect seizures and forfeiture of IRGC-associated assets pursuant to statutes regarding civil forfeiture, including of maritime shipping vessels and cargoes, and regarding federal crimes of terrorism. The latter, 18 U.S.C. 233-2B, specifically grants extraterritorial and special maritime jurisdiction, and is the section most frequently cited justifying seizures of Iranian-related shipping. Presuming the U.S. has jurisdiction, 14 U.S.C.A. Section 522 authorizes inspection, seizures, and arrests on the high seas for violations of U.S. law. Under 28 U.S.C. Section 1333, the U.S. government must assert a claim in rem under admiralty jurisdiction to seize a ship or cargo. Obtaining a warrant to do so requires satisfying two conditions: relevant location and a nexus with maritime activity. The location test asks only whether the tort or injury occurred on a navigable water or vessel thereupon. The nexus test requires that the court assess both whether the incident was disruptive of marine commerce and two, whether the incident bears a substantial relation to traditional marine activity. In cases involving a marine tanker allegedly smuggling contraband fuel while transiting the open ocean, fulfilling the nexus and location test is straightforward, so long as the U.S. has other statutory basis for the seizure. There's a question as to whether the U.S. government could secure jurisdiction to seize vessels on the high seas through FISA. There are exceptions to Foreign Sovereign Immunity Act. There are exceptions to the Foreign Sovereign Immunity Act that could be implicated, including those regarding the U.S. Victims of State-Sponsored Terrorism Fund, which is funded partly through sales of seized Iranian property. Sovereign immunity under the FSIA does not extend to government vessels being used for commercial purposes, but it does apply to warships. Interesting. In the modern era, Congress authorizes seizures of vessels and cargoes on the high seas for violations of U.S. law. Seems clear to me. That's fine with me. And courts have repeatedly authorized the sale of extraterritorially seized Iranian property to fund the fund. Essentially, the FSIA strips immunity where a suit is brought in admiralty to enforce maritime liens against a foreign state's vessel or cargo, and the U.S. government is bringing suits to enforce maritime liens to fund awards and U.S. court judgments to victims of Iranian-backed terrorism. Oh, shit. Wait. Let me see if I understand this. So, here's a theory of the United States. Ready? You owe us money for various different reasons. And when we seize these vessels, we're doing so to enforce judgments and give it to victims on other things. Though high seas seizures clearly conflict with international law, an aggressive U.S. administration might find this legal avenue tempting. However, domestic authorities only work domestically. The U.S. would need to couch its actions so that the international community cannot fairly view them as unprovoked illegal attacks on foreign merchant shipping. This is a tall order. Interdicting foreign shipping without a solid legal international basis would seem to be precisely the kind of coercive behavior that UN Charter Article 2.4 bars because of its corrosive potential. Okay, I mean, I think that I'm going to keep reading this later. But here's where I'm at. It seems like vague and uncertain regarding, we have a Fifth Circuit precedent on the jurisdiction of the courts. Unclear the jurisdictional issue. Unclear how there's violations of U.S. law, in my opinion. Maybe you can get it through these other creative means. But at a bare minimum, you're violating international law, right? Because this isn't a seizure that is justified by the 1958 convention. And the whole point was whether these requirements that America signed on to are self-executing, not that America has signed on to them. So it's a kind of like at least at first glance, it appears to be a violation of the United States commitment to follow this 58 convention. Interesting, man. Hey, yo, appreciate you, the Kick viewer who brought this to my attention. But yeah, I would still be against it as a violation. If I have to do more reading, obviously, but if there's a self-standing violation of international law to which America is a party, I would be against it. If it's a violation of U.S. law, it really does seem like lack of clarity on the jurisdiction issue, and then I don't really know much about the honestly how there would be a violation of U.S. law unless there's some nexus to a U.S. principle or something. Why we would have this extraterritorial application of U.S. sanction law to other states, to like Iran, such that it's a violation of U.S. law for Iran and Venezuela to trade in oil because they're evading U.S. sanctions. That, like, how do those apply to those countries? But even putting that aside, I think just the fact that this is an additional escalating act that could very quickly lead to an unjustified war, I think, is problematic enough. And the way to, I think about this is, suppose that someone tried to like stop a U.S. vessel that was ignoring some kind of sanction. Let's say that there's a bunch of sanctions, hypothetically, let's say a country, I don't know, pick it, Israel, right? And in the high seas, and like Russia claimed that this was a violation of like Russian sanctions. I don't know, assuming that Russia sanctioned Israel. It's kind of a more weird relationship than, strictly speaking, adversarial between Israel and Russia. But just take that example, right? And they, in America's like, I don't give a fuck about what Russia says about its sanctions. We're just going to go and do it anyway, right? You can sanction whatever the fuck you want. And then Russia like seizes a U.S. vessel selling sanctioned oil from the Russian perspective to Israel. We would see that as an act of war, an act of aggression, and it would be in violation of these conventions. Whether it's a violation of Russian law, who the fuck knows? Oh, he's done streaming? Cool. Okay. And where else am I? Fuck. Last other thing. I also want to talk to him about the Ethan Klein thing, but I can just bring that up when we talk. All right. What do we talk about? Let me start with Kilmar. Let me go big picture for y'all. It's so insane to keep reading the updates on the Kilmar case and how much the administration has just fucked with this dude nonstop. It's almost like a Kafka-esque nightmare. Is that the right word? There's Kafka-esque. Is that a thing? Did I say that right? Kafka-esque. Meaning nightmarishly complex, illogical, and bizarre. Yes. portrayal of oppressively complex and seemingly illogical bureaucracy. That's exactly the term I would like to use to describe the situation of Kilmar. So remember how this all began. Kilmar was picked up earlier this year. Fuck, is it this year already? It's almost over. Year's almost over, guys. We survived almost a year. Don't count your chickens before they hatch, though. It hasn't been a full year, so don't say it yet. And he was basically put on a plane immediately and deported within days without any due process whatsoever. So not only, like, obviously, like, violations of the due process clause, unanimously upheld 9-0 in the Supreme Court that, yes, even quote-unquote illegal immigrants are granted due process on their removal proceedings. That's 9-0. And he had already won, like, the major form of relief that he sought when his first immigration case happened. You have to understand, withholding of removal is a kind of harder to get version of asylum. It's harder to get because, A, there's no time cap to it. So there's a year requirement. You have to apply for asylum within a year, except for certain exceptions. And so it's harder for that reason, that there is no cap for withholding. And it's also harder because it's mandatory. Asylum is discretionary. That's one of the reasons why this whole cope about the guy who shot the National Guard people, that he was, like, granted asylum by the administration. Like, this whole notion that, oh, they had to do it, their hands are tied. They weren't tied. The Afghan national who shot the National Guard people. Not that I, like, necessarily blame the Trump administration for that. I'm just applying their standard of correlation equals causation. When something bad happens in the country, we blame whoever's in charge. See, for example, the economy. But asylum is discretionary. Withholding is not. Withholding is not. It's a harder form of thing to get. And there are far fewer grants of withholding of removal than asylum. People typically prefer asylum. Asylum is a pathway to a green card, which itself is a pathway, if you would like to naturalize and become a citizen of the United States. But that's not true of withholding. Withholding just prevents the government from deporting you to a particular place. However, that being said, it acts as a kind of pseudo-status, and has for decades and decades and decades. Very seldom does the government choose to deport someone who's granted withholding. As a matter of just policy, generally, once you make the showing that, hey, it's basically like, you should have gotten asylum, and the reason you didn't is probably some stupid, like, procedural thing that you weren't eligible for it for some reason. But for whatever reason, we can't grant you asylum. Maybe you're disqualified for it. But here you go, take withholding. And so in general, that's like the big substantive hearing that you would get is on the withholding issue. And once you grant it, the government would tend to leave you alone, let you live out in America, give you working papers. You have to check in, right? And so it's not surprising, right? That's what happened. And he was granted withholding in 2019 by the Trump administration, by a member of the executive branch. Don't get confused like this dipshit. What's this guy's name? They gave this guy a press pass. This guy is sitting in the Department of War as a Pentagon person. Cam Higbee. This, like, I don't want to say, I'm not going to say the word, but you know the word. This person. He's like, these judges, the judiciary, bro, they're members of the Department of Justice. The Trump DOJ granted Abrego Garcia withholding. So it wasn't some liberal judge that was under, a lifetime appointee by Obama. It was someone under the direct supervision of Bill Barr. Okay? And by definition, therefore, Donald Trump. Okay? So he goes about his life. He checks in with ICE all the time. And then he enters into this Kafka-esque nightmare. And this is the culmination. I mean, it's not over yet. They're almost certainly going to appeal it. But I fucking called half of this shit. Oh, you can't see it. My bad. One sec. I fucking called half of this shit. And when you start to see how Judge Dennis summarizes everything that's been done to this dude. It's equal parts ridiculous, but also like horrifying. Like, this guy should be getting millions of dollars, and he'll never get that, unfortunately. Though I would, if I were a member of Congress, advocate for it. But yeah, he should be compensated for all the shit that he's going through. But this is a habeas petition. So Abrego Garcia gets sent to CICOT, this torture dungeon in El Salvador. He was sent to the place he specifically was not supposed to go back to, pursuant to his withholding order. And the Trump administration says he's never coming back. As you recall, Judge Zinnes, the person who's writing this opinion, orders that he be his return be facilitate his return to the United States. And the Supreme Court upholds that 9-0 in a 9-0 decision. But then afterwards, they're still like, nope, we don't have to bring this dude back. No need to bring him back. After that, they actually bring him back, though. After they defy the court order, they bring him back, and they parole him into the country, ostensibly for the purpose of charging him in this kind of bullshit manner. And so far, the case looks incredibly... there's a lot of speculation, let's say, in the indictment, to say the least. And he's indicted and put into pre-trial detention and wins his appeal with the judge to get released on bond. He's released on bond, and this is a court in Tennessee. The Trump administration's like, hey, this is some liberal activist judge releasing this gangbanger, and we're not going to stand for it. Let's let's just put him in immigration detention, and we're going to send him to Africa. Not joking. I'll show you. I'm not going to read chapter and verse the entire opinion, but we'll jump to the part where they're like debating on which war-torn country in Africa, or at least, I don't want to pretend that all of them are war-torn countries, all right? But like, which country in Africa to send Kilmar, and all the while like lying and fucking up basic procedure. Anyway, this is a petition for a writ of habeas corpus with Judge Zinnes. So after there was the lawsuit to bring him back, now it's a petition for habeas corpus. And that is, as you guys probably are well aware, a request to challenge the lawfulness of one's detention, where the relief is usually, although if you ask the Supreme Court, they kind of took a weird view, if you ask me, on this issue, usually to release the person, challenging the legality, in other words, of your detention, and seeing if you ought to be released. And Abrego Garcia, after he was released from custody and pretrial detention for the Tennessee criminal matter, within some days, he was picked up by DHS and put in immigration detention with the rationale of, we'll send him to Africa, so we need to detain him while we're organizing his imminent deportation to Africa. Okay? And let me cut to the chase on a few things. Number one, at some point, it does seem, in my opinion, unless there's some legal constitutional principle that I'm ignoring, that there ought to be some authority, or there is some authority for the United States eventually to deport Kilmar. Now, I'm not saying that I can't be convinced that there is some other substantive basis for him to stay in the country, but I'm not sure that if the administration, who is intent on deporting Kilmar, that once they get their ducks in a row, they're not going to be able to do it eventually. And I've been upfront about this the entire time. Maybe there's something I'm missing, but as I understand it, right, he is removable. And he is, in fact, not eligible for a form of relief that would entitle him to stay here, except for like withholding the Convention Against Torture, those kinds of things. But again, that stuff doesn't apply necessarily. That's like on a per country basis. And so wherever if they send him somewhere like Costa Rica, the claims about withholding aren't transferable there. Asylum is a little different. That gives you like an affirmative right to be here and live here, if you get it. If it's granted to you and eventually you become a green card holder. Is Andrew Wilson still documenting? Yeah, always. Andrew Wilson's documenting. The dude is, he's scared. What can I say? Anyway, the history of Abrego Garcia, long story short, the court grants his habeas petition and says he must be released. And says that Abrego Garcia's detention, remember, this is about detention, is without any legal authority. And so Zinnes orders him released. The history of the Abrego Garcia case is well known, as it is extraordinary. The court will not recite all of it here, but only those events necessary to explain why Abrego Garcia is entitled to immediate release. Abrego Garcia is a national of El Salvador. At 16 years old, he came to the U.S. as a non-citizen to avoid persecution from Barrio 18. He worked in Maryland, blah, 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 blah. When he was initially picked up, again in 2019, he asked an IJ for 3 kinds of relief. This is withholding. That's the one that was actually granted. Statutory withholding of withholding. The statutory withholding is what was granted, this one. But he also applied for CAT. I don't think they reached it because they got the withholding. The withholding is more protective. And asylum, which was not granted because he did not apply within a year after he entered the country. So at 16, he entered in 2012. Now, I believe the asylum 1-year rule is told while you're under 18, but once you turn 18, it kicks in. So you have to apply within a year when you turn 18. Got it? So he applied for those 3 kinds of relief. And these are usually they're actually applied for oftentimes all on the same form. And this is a form of defensive relief. So you can apply affirmatively for this kind of status with USCIS, but you can also apply what's known defensively when you're put into removal proceedings. And so he's put into removal proceedings, and he's told the judge, listen, I think that I'm entitled to this kind of relief. And this just explains what it is, which I kind of already explained. So you have CAT, withholding, and asylum. Abrego Garcia testified and was found credible by the IJ. They granted statutory withholding, denied the remaining requests. And they memorialized this determination in a written memorandum of decision and order. Now, this order is very important, folks, for what it says and what it does not say. And I fucking called this when I was debating these fools. These fools were like, just remove him. And I'm like, I don't think that there's an order of removal here. And they're like, oh, Rob Noor said something so, like, this guy's so ignorant, Rob. He goes, there was a general order of removal given. But like, there wasn't a final order of removal in the case. As you'll see, that'll be fatal to the case here. The October 10th withholding decision referenced a procedural history. Abrego Garcia's concession at a prior hearing that he was an El Salvadoran national who entered the U.S. without lawful permission, and the IJ found his removability to be established by clear and convincing evidence. So there's a judicial finding, but when I say judicial, I mean at least the IJ, an executive finding, that he is removable by clear and convincing evidence. So the only question left is, does he get some kind of relief from removal? Okay? Because he concedes he was a citizen of a different country. He concedes that he entered without permission. And additionally, that therefore he's removable. There are bases of inadmissibility that would apply to him. And if you haven't entered with inspection admission, the bases of inadmissibility apply to you such that you can be removed. And so one of the bases, for example, that makes you inadmissible is crossing the border illegally. Another thing is being here without any kind of status. Can make you inadmissible. Actually, I believe that's only applicable if you stay past a certain time period that makes you inadmissible and then leave the country. That's a precise point that you practitioners out there might know. Nothing suggests that IJ, I keep saying IG, Abrego Garcia removed to El Salvador. In fact, the withholding decision twice erroneously suggested that the stated country of removal from which Abrego Garcia sought relief was Guatemala. So already some problems with this IJ. You're getting the countries wrong, man. What's going on, Mr. IJ? But Judge Zinnes is like, hang on. So like, where's this order of removal, right? The thing that you say that you have, where is it? And they're like, some problems here. The judge seems to be under the impression that you're going to the wrong place, Guatemala. The withholding decision also included a separate order that did not command Abrego Garcia's removal to El Salvador or anywhere. The order read in its entirety. So this is Judge Zinnes, right? So imagine that you're a conservative trying to deal with these facts. Imagine that you're a MAGA bootlicking shill trying to deal with the facts here at issue. It is hereby ordered that the respondent's application for asylum is denied. The respondent's application for withholding removal is granted. And CAT is denied. That's it, right? Does that look like an order to remove someone, right? Now, they found that he's removable. But does the order him removed? Well, as I read it, no, right? For the next 6 years, he worked pursuant to an ICE order of supervision. But on March 12th, 2025, the fateful time, the dark days, he was taken to El Salvador, where they were detained in the terrorism confinement center, CICOT. While at CICOT, the men, including Abrego Garcia, were systematically beaten and tortured. Which is, like, all these people should be fucking rotting in jail. Everyone involved in the... I'm not talking about the people who were sent there by the administration. I'm talking about the people who sent them there. Not the people who were sent. You get me? People like Kristi Noem. They should be rotting in a prison. Only our prison would be not torturous goons. It would be a humane prison where someone like Kristi Noem, minimum security. I'm not even saying maximum security. Maybe just for a day to see what it was like to be illegally sent to a torture dungeon. But, maybe some specific deterrence or something. In response, Abrego Garcia filed in this court and separately removed for an injunction. And this is the procedural history I talked to you about. Facilitate and effectuate return. It went all the way to the Supreme Court, and they affirmed the order as modified to command the facilitation of his return to ensure that his case be handled as it would have had he not improperly been sent to El Salvador. In the ensuing weeks, respondents refused to facilitate Abrego Garcia's release of his return. So this is Judge Zinnes noting for the record, as she has multiple times, the defiance of the White House here and of Trump himself. And it's worth just getting mad about this again. The White House announcing that Abrego Garcia is not coming back, is never coming back. An interview with President Trump wherein he confirmed he had not asked the president of El Salvador to release and return Abrego Garcia. A post from DHS confirming he will never be allowed to return to the United States. See also a post from CNN. Trump says he could bring Abrego Garcia back, but he won't. So, very clear acts of defiance, right? Imagine that you were a normal person and the law applied to you and you had to actually follow the law, unlike this government of ours that gets like 1,000 different chances to break the law and do what the fuck it wants to do. Imagine that you were like, yeah, I'm not just going to do that. I'm never going to follow your order. Seems pretty like defiant to me. It seems like you're... So this is one of the areas where people really challenge me. Trump has never violated an order. No, they definitely did. This is the administration declaring that it will not follow an order. That is a violation of the order. They didn't facilitate his return until they decided to later on. And it's not good enough to be like, well, eventually they brought him back. No, you were ordered at that moment to facilitate his return. And you didn't start doing it. And you didn't try to do it. You renounced any obligation to do it. And therefore you were in defiance and violating the order. However, on June 6th, the respondents paroled Abrego Garcia in the United States after securing a federal indictment in Tennessee. A matter that is itself under scrutiny for vindictive and selective prosecution. Not too dissimilar to, we're not going to talk about it too much today, but I heard, a little birdie told me, that a grand jury, once again, no-billed the indictment of Letitia James. What a great record, guys. I mean, this has to be one of the strongest cases for vindictive prosecution in the history of the United States. Both Comey, I don't know who has a better one, Comey or Letitia James. What an embarrassing mess. What a bunch of losers they got. Anyway, he was released in the Tennessee matter on stringent conditions of supervision, but respondents found this result intolerable and complained bitterly. And look at this footnote, guys. Look at them. DHS. This is a lawless judge. This MS-13 gang member, human trafficker, and illegal alien will never walk America's streets again. Trisha McLaughlin, this ghoul, this absolute ghoul, stating, it will be a cold day in hell before this criminal illegal alien is back on American streets. Noam says she's the worst of the worst. See also Trisha McLaughlin. Kilmar Abrego Garcia is a dangerous criminal illegal alien. We've said it for months and it remains true to this day. He will never go free on American soil. And this is another one, a Newsmax clip of this ghoul, Trisha McLaughlin. This is a man who should not be on U.S. soil for long and won't be. So they were pissed. Respondents also warned Abrego Garcia that upon his release, ICE would take him into custody to effectuate his removal to a country other than El Salvador. Abrego Garcia, in response, urged the court to order his return to Maryland under the ICE supervision terms that were in effect prior to his wrongful removal. The court agreed and ordered Abrego Garcia's release and return to ICE supervision out of the Baltimore field office. The court also ordered that in the event they initiated third country removal proceedings, they give Abrego Garcia 72 hours notice. Meanwhile, during plea negotiations in the criminal case, Costa Rica, this shit is wild. I never actually covered this because there's like direct, I got distracted on some other shit, but there's direct evidence that they're lying about this Costa Rica shit. So, is that better? Okay. Imagine you're Costa Rica. Costa Rica, you see like a fellow Latino getting pushed around, sent to torture dungeons. You come out like a boss and you say, official correspondence from Costa Rica's Minister of Public Security. And good guy Costa Rica says, can we get some blue guys W's for Costa Rica? Just being a good guy Steve. Is it scumbag Steve or good guy Steve? Is it good guy Gary? It might be good guy Gary. You guys can hear me, yes? Is this thing on? W Costa Rica. Okay, cool. The government of Costa Rica, official letter, intends to provide refugee status or residency to Mr. Abrego Garcia upon his transfer to Costa Rica. The government of Costa Rica assures the government of the United States of America that consistent with that lawful immigration status and Costa Rican law, it does not intend to detain Mr. Abrego Garcia upon his arrival in Costa Rica. The government of Costa Rica further assures the government of the United States of America that it will not remove Mr. Abrego Garcia to any third country, including Mr. Abrego Garcia's home country, without Mr. Abrego Garcia's consent. Look at this Costa Rican government. They're coming out for our boy. I say our boy Kilmar. Listen, this isn't about Kilmar the person. It's about the power of the government to ignore the law. But it is, I think, incredibly depressing that countries that America always feels like it's superior to apparently understand humane application of law better than our country. But anyway, good guy Costa Rica comes in to save the day. And Abrego Garcia gets word of this, all right? So Abrego Garcia, there's rumblings. They understand that Costa Rica has given consent to take in Abrego Garcia. Okay? The next day, Abrego Garcia left the detention center in Tennessee. Respondents served him with a notice to appear. So they, right outside the detention center, they give him an NTA. An NTA is an official charging document, okay? It's an official removal it's how you initiate proceedings, removal proceedings. And so they NTA him, all right? And they've been doing this not just to the celebrity people they've tortured, right? And the only reason Kilmar is a celebrity is because of how egregious the conduct of the government is. It's their own fault that they've created this very internationally known case because of how defiant they have been. And if they had just been doing shit in good faith, he probably would have been able to deport them already. But they're so stupid, they're so short-sighted that oftentimes I think that their maliciousness and viciousness and evil nature and tendency to like maniacally laugh and just be cruel and unusual gets them into trouble so far as PR is concerned. And so, but they're not just doing it to these people. They're NTAing people at like their citizenship hearings after they've gone through everything to actually just swear in to become a U.S. citizen. They're NTAing them. All right, so they NTA Abrego Garcia as he's about to leave his criminal matter, which again, this like trumped up charge. Listen, there might be. I am doubtful of this theory that you can charge anyone who like moves someone who's here without status. Right? Like, what the fuck? So Uber is now violating, is doing felonies? That's crazy. Or like the state of New York, let's say the state of New York has like public transit. Is the state of New York? This is exactly no more no less what like Ron DeSantis and Governor Abbott were doing. They were moving these people around. It's like a ridiculous theory. Oh, because this guy provided transportation for people? Shit. Then we got to throw a bunch of other people in jail. Anyway, they NTA him outside the detention center. Respondents separately notified his counsel that respondents here is the government. So when you see respondents, you should read Trump, all right? Trump separately notifies his counsel that they intended to remove Abrego Garcia to Uganda. Yeah, so the first country they try to say is Uganda. And Abrego Garcia immediately responded with written notice to respondents of the fear that if he was sent to Uganda, he would face persecution, torture, and ultimate refoulement to El Salvador. So, first of all, he doesn't fucking know anyone in Uganda. And he's saying, I would face persecution, torture in Uganda, but also I might be refouled to El Salvador. And that's like a big no-no. You're not supposed to do that. You can't just like go around our international treaty obligations and our statutory withholding and asylum laws and bring people back through these creative, artful maneuvers and refoul them in the country that they're not supposed to be brought back to. He also separately notified respondents in writing that Costa Rica was the country to which I want to be removed. So the law also, additionally, on even just putting aside the humanitarian nightmare that is being suggested here by the administration, and they're really just trying to use these African countries to like scare them into complying and just like, okay, you can send me out, you can deport me. Stop fighting, stop resisting. We'll make it tough for you. We'll send you someplace. Do you guys ever watch The Wire? Any of The Wire fans here? We got any Wire fans? Thank you for pissing on the regime's mouth. Oh, happy to do it. Okay. Do you remember when McNulty, at the end of the first Wire investigation, he talks to Freeman, Detective Freeman. He's like, tell them where you don't. They're gonna ask you where you don't want to end up, acting all nice and stuff. Lie. Don't tell the truth. And then ultimately someone like talks to because they're pissed at him and they want to, because he pushed and embarrassed the higher ups, they want to send him where he doesn't want to go. And so that's how these motherfuckers, they use their power at every opportunity to fuck with people and to be as cruel and petty as possible. And so they're like, we'll send you to Africa. And he's like, I don't want to go to Africa. If I'm going to be removed, send me to Costa Rica. And that, in addition, again, like I said, to the humanitarian aspect to it, the pettiness of it, and the international principles of refoulement, etc., there's also a U.S. law about removal, and specifically to third countries. That if you want to do a third country removal, there's like an order of operation that you follow. Where do you want to be removed? Actually, this is for all removals. We want to remove you. If you're going to be removed, where do you want to go? And if you don't select, there's going to be a default, and then if not that one, somewhere else. And so, and in the order, the first thing that's usually like the first order of operation is wherever the person says they want to be removed to. Now, there could be different statutory reasons why you can't remove them to where the person, like, imagine that the person's like, I want to be sent to North Korea. Like, obviously not super possible to, be sent to places that won't accept you, for example, or to where the America doesn't have any like diplomatic relations. So it's not like you have to go with that if it's impractical, but you have to follow the statute, in other words. And there's a separate issue about whether they even followed that. So like at every level, just note that like it's very possible that I'm glancing over some other violation of law or some other principle or some other like corruption or some other fucked up shit. And if I didn't happen to know that there's also litigation and briefing on this issue of the removal statute and what order to do things in, like you wouldn't even know about it. But like just know that at every possible stage of the litigation, they're saying it's unreviewable, and also like we have the complete right to send wherever we want to go, and yet we don't have to follow the statute. Even the statute says you have to like do this order of operations for removal, and like we're glancing over other like every part of this. This is a heavily litigated case. I'm sure he has some big law firm helping in. I forget which law firm it is, but this is a case that has many associates on it, guaranteed, because it just constant wave of litigation and motions and. Like I said, motion practice and other paperwork and just keeping up to date on facts. And so this is a highly, highly litigated case. And at every stage, the government is trying to be as petty and vindictive as possible and claiming they don't have to follow anything. Abrego Garcia next appeared at the Baltimore ICE field office as directed. He was immediately taken into ICE custody, according to DHS Secretary Noem. I mean, think about this, right? The head of these agencies are like doing updates on their Twitter feeds about this specific removal. And this guy, you know, say what you want about this guy. It's not like he's being alleged to murder anybody. He's not being alleged to be, you know, even to the extent that they're alleging that he's a gang member, which are preposterous allegations that have no public evidence supporting them. Maybe there's something buried somewhere. But if there was, I'm pretty sure we would have heard about it by now. If there was some smoking gun. But maybe there is, but if there is, we haven't seen it. And they've maintained always, oh, he's a gangbanger, he's a... But, like, there's just no evidence, really, that's available that suggests that. And you saw the lie about the fucking tattoo that Trump's, you know, this demonic, aging, failing president, alleged president, said about the tattoos. But, yeah, it's... Part of the Kafka-esque nature of it is you're being stuck in these like litigation circles and like things. Imagine being him in a whirlwind where the president is regularly commenting on your case. Whole nations are fighting over where you know to go. They're trying to seal different records of like state diplomatic communications to hold you. And like, it's not just some random case agent. The director, the secretary of Homeland Security herself is like, for political points, possibly angling for a run for the presidency in 2028. Delusional, never going to happen, never going to ever happen, has no chance whatsoever to become president. I will stake $1,000 on that claim right now and no more, because fuck, I don't have any confidence that we don't elect. I really do think that she has like very little chance. But a DHS officer who absolutely has grander ambitions, perhaps even to seek national office, is giving case updates on you, on like your life, and sending you to Africa. Bizarre, right? Like nightmarish in its nature. Anyway, keeping to go. Abrego Garcia in turn filed a petition, this petition, right, for habeas relief, contending that the removal to Uganda violates 8 U.S.C. 1231 B2 and B3 of the INA, that respondent's third country removal policy deprives him of procedural and substantive due process, and that his detention is without lawful authority in the absence of a valid removal authority. So understand that there are statutory issues here, because the question ultimately hinges on, at least for purposes of this order, whether his detention is lawful, whether he ought to be released. And that, of course, is going to turn on the authorities that the public has to keep him in custody. As a default, right? Like, the country doesn't have like this assumed authority to just detain people all the time, no matter what. It's kind of like what I was talking about when it came to the strikes, the strikes of the drug boats or whatever, the alleged drug boats, that there needs to be some authority from which the use of lethal force is authorized. It's not just, you shouldn't assume that they have this authority to do so. And what Abrego Garcia is arguing is that there's no actual authority here to detain me, and to continue to detain me is illegal because it violates various statutes and also the Constitution. And we'll talk about that for a little bit. The petition also challenged the constitutionality of Abrego Garcia's continued detention pursuant to 8 U.S.C. Section 1231A6 under his Advitus versus Davis because, quote, no significant likelihood of removal in the reasonably foreseeable future exists, thereby undercutting any claim that he was being detained for the purpose of third country removal, the Zedvitas claim. This is an interesting case because it deals with a situation of a person who is detained domestically, who is not allowed to be here, who is removable. I believe this is a Breyer opinion from 2001. But there just like is no prospect that they are legally going to be able to send him in anywhere else outside of the country. And the question is, from a perspective of the Constitution, does the Constitution allow you to detain a person for an indefinite period of time on the basis of, well, we want to remove him, but when you have no expectation that you can actually remove him in the near future? In other words, can we just give life sentences to people who, for whatever reason, the government is unable to remove? Just as an incident of them being in the country, would it comport with the Constitution or, crucially in Zedvitas, an interpretation of a statute to allow that? And I actually believe the holding of Zedvitas was that we, kind of a constitutional avoidance analysis of the statute at issue there, that because the indefinite detention of a person incident to their removal or on the basis of future removal, that if that were to be allowed indefinitely, it would have serious constitutional issues or concerns. We're just going to read the statute, Congress as not having authorized that. And so we're going to read the statute as limiting the ability for that in for some reasonable foreseeable future. And he picked 6 months. So needless to say, I think that there is a central procedural issue here, in my opinion. But notice the potential divergence with other case law, where there is a situation where, I forget the exact case name, someone was being brought to Ellis Island. And this person had been a resident before, I believe, but had joined the Communist Party or something and was trying to get back in the country. And they are going to remove him, but they don't actually have a place to remove him to. This might be the Mazzei case. This might be the Mazzei case. I'm not sure, though. Someone can quote me on that. But anyway, the Supreme Court, and this is back in the day, decades before the Zedvitas case, whatever case that I'm referencing, it might be Mazzei. In that case, they said, we could hold him in Ellis Island indefinitely, and we don't have to give him the evidence for why we can't bring him back or, remove him or something. So it appears that the court gives a different gloss of procedural protections for someone who is within the country, as opposed, even in this context, even in the context of indefinite detentions, versus someone who's, at the posture of, approaching the government or trying to enter the government, or the country, sorry, I should say. But it's kind of a legal fiction, right? Because Ellis Island is in the United States. It's part of the United States territorial sort of scope, right? It's part of America. So it's a kind of weird. I understand this is the doctrinal distinction in many of these immigration situations, and it's one that I pushed on Tim Pool as well, as being yeah, okay, at the point of entry, very different case law. But it's a little harder to see what justifies that. You're technically on American land when you're on Ellis Island, so it's some kind of application of a legal fiction. So just keep that in mind. But it does appear that's what the court is talking about here. That there's in addition to the due process issues, the actual due process issues, and the actual INA issues. Thank you so much for the super chat from Pondering Politics. Bro, the MAGA rage over Indiana is delicious. Your buddy Will Chamberlain is so mad. Let's delight in the despair. It's sweet elixir. Thank you so much, Josiah. Appreciate you. Yeah, no, I saw the most cucked tweet I've ever seen. God damn. And we'll get into Pavlov in a second. But just give me a second to where did I see this cucked tweet? Look at this motherfucking loser. And retweeted by the Bulwark. Naughty, Bulwark. Naughty. quote, gonna throw this out there. If Indiana Senate votes this down, Pritzker should announce he's taking redistricting off the table. Have you ever read a more cucked message in your life? Seriously. Someone's got to help me ratio this fool. And look at all the replies. Let's go down. Fuck that. There could have been a West Wingy moment in which Indiana, Illinois, Maryland jointly said no. Or you can just do journalism. Hell no. You just don't learn, don't you? Absolutely not. Hurt them. Make them pay for starting this fight. Force them into the corner. Make the GOP beg for national gerrymandering reform. Stop taking our fucking foot off the gas for once and finish the fight. God damn. Give it right to my veins. Nay, shows of good faith don't win elections. Nope. Full steam ahead. Absolutely not. Bet Fatso doesn't. Fuck all you GOP repliers. See, they don't appreciate shit. They don't appreciate shit. Even when you go on like, guys, we can all just de-escalate together. We can all just be, good people together. They're like, they don't want your pity. They don't want they only understand and respect one thing. And that's strength and consequences. That's the only thing they understand. Strength and consequences. Absolutely not. That feeling you have wanting to extend an olive branch is why they call Democrats weak. No more. Still playing the nice guy, huh? That worked so well for the Democrats these past 15 years. No, he shouldn't. No. DeSantis is going to go full blast in Florida. Got to offset that. Are you unaware that other Republican states exist? Absolutely not. Nope. You're showing your poker hand. Nope. No, double down. Huh? Nope. We're playing for keeps. Nope. Florida's planning to do so once Florida's off the table. I would say no. I don't give a fuck if Florida's on the table, off the table. You go. We still need to counter other GOP gerrymandering. If Missouri does the same, sure. No. I mean, God. Nope. Stop the shit. Like, what the fuck is this? This is the kind of... And Bulwark retweets it? The Bulwark. And then I ponder and I'm like, wait a second. The Bulwark is all filled with enlightened centrists. These bastards. Anyway, thank you, Josiah, for the super chat. Okay. Okay. So that's the first issue is, are we authorized under the INA? Are there issues with procedural substantive due process? And are you able to detain without a valid removal order? Also, under the Zedvitas interpretation of 8 U.S.C. section 1231A6, are you able to keep me there? So multiple bases to suggest the removal is unauthorized. And the question is on whether or not his detention pending removal is justified, is legal. Okay? Sam Stein is an editor at the Bulwark. Oh, I didn't know that, so I look dumb. Oops. In the days that followed, respondent took no steps to process Abrego Garcia for removal to Uganda, ostensibly because of his claimed fear of persecution and torture in that country. Instead, on September 5th, I laugh because it's so, this is the Kafka aspect of it. It's like, we're going to send it to Uganda. No, we're going to send you to Eswatini. And then I said, okay, I also fear the same things with Eswatini. Within days, Eswatini learned of respondent's notice to Abrego Garcia, and it bit back. On September 11, 2025, Eswatini's spokesperson, I can't even pronounce this, announced that the government of Eswatini had not received any communications regarding this person and did not have any agreement with the U.S. to receive Abrego Garcia. So think about how crazy what the government is doing right now. They're like just trying to scare Abrego Garcia and with like, I don't know, African countries. And they're not even coming to an agreement with some of these African countries on accepting Abrego Garcia. Meanwhile, they have the message from Costa Rica saying, we will provide him with an estate to live on with servants, and we will not torture him as you have done. And they because think about it, all they want to do, they don't actually just want to remove him. They want him to remove him to somewhere that they consider to be like a bad place, a worse place. And they're like, oh, Costa Rica? He'll feel more comfortable there. Let's send him to Uganda or Eswatini. because we just want to be as cruel as possible, because that's our aim. Our aim is to be as cruel as possible. And so even though we have Costa Rica saying, we'll take you in, Abrego, and it's all ready to go, they're inventing agreements with other African countries that don't even exist just to fuck with this dude and to make him more uncomfortable. If they were like, if all they cared about was what they said, why wouldn't they, first of all, why would they try to deport him right now anyway, right? Presumably, the whole pretense of this is we brought him back into the United States so that he can face justice in Tennessee. So you're going to deport him before his criminal proceeding ends in Tennessee, even though that was the whole reason you brought him back into the country, right? It makes no sense. It makes no sense. 0 sense, right? So now we're going to deport them before we do the thing that was the supposed reason we brought him back. Having heard nothing, and with the October 6th hearing approaching, Abrego Garcia asked the court to order targeted discovery on the respondents' plans to remove him to Uganda or Eswatini in lieu of Costa Rica. Respondents, for their part, asked to continue the evidentiary hearing, so the court converted the evidentiary hearing to an in-person status conference. At the conference, the court tried to assess whether respondents had made any real effort toward removing Abrego Garcia in conformity with Zedvitas. It quickly became clear they had not. Respondents through counsel, this is so crazy, could say no more than Eswatini had been selected for Abrego Garcia's removal. What's crazy is what the government is doing is they're selecting lawyers that don't know shit about anything. And they're not just that for the DOJ, witnesses. You're going to see in a second the witnesses that they provided for some of these evidentiary hearings. It is insane. You want to talk about Kafkaesque? Look at what they're about to do. Nor did respondents have any further details about whether any efforts had been made to secure removal to Costa Rica. This was so even though Abrego Garcia reaffirmed that he would depart this afternoon for Costa Rica, thus obviating the need for any further hearings or adjudication of this petition. If the government's goal is to effectuate the removal, he would be in Costa Rica right now as we speak. Footnote 8. Despite the intense global attention paid to this case and the purpose of the status hearing, counsel for respondents came to this hearing supposedly unaware of any removal efforts pertaining to Abrego Garcia. Even with a recess, counsel still could not reach anyone that could provide an answer. So the lawyers that they're picking for this case, they're like changing them all the time, and they don't even know the basic stuff about the case. To put it like into a more specific focus, they don't even know whether or not they're trying to remove Abrego Garcia. The lawyers they're selecting, right? The lawyers they're selecting for this case can't even confirm whether or not they are trying to remove him as of now. What the fuck? What is this whole thing about? This whole thing is about that. I laugh just because it is you have to. It's so ridiculous. Because respondents had done nothing other than send emails to Abrego Garcia's lawyers about removal to Uganda and Eswatini, Abrego Garcia asked the court to rule expeditiously on the Zedvitas claim. Respondents in turn asked for an evidentiary hearing to the government to demonstrate the sincerity of their third country removal efforts. Right. So the whole purpose of Zedvitas, and because there's like a time window in which it's presumptively okay to keep them around, but you can overcome that with other evidence. And so you have this evidence to show, well, we're really trying to remove him to other countries. And so, of course, like, okay, government, we'll grant your request, and let's see what you got. Let's see what efforts you've made to try to remove this person. Understand the kind of nuance here. So the nuance is, you can hold them so long as you're holding them. If your reason to hold them is to effectuate removal, you can hold them so long as you're either trying to remove them or there's a reasonable certainty that like within some near future, you're going to be able to remove them, right? And so the sincerity by which you're trying to remove them is relevant to whether or not there's any indication that you're going to be removed soon, such to justify your continued detention, right? Zedvitas is about detention and detention incident to a purported removal. And so that's why this is relevant. So bring in your witnesses. All right, court says, okay, government, you can come in and you can talk about like what efforts you've taken to deport Abrego Garcia to a different country, because that will help determine whether or not we should grant the habeas petition, because it helps determine whether the Civitas claim is applicable. That's like the legal logic of it, okay? The court granted the requests and wanted them to produce a witness or witnesses to testify about what steps, if any, respondents have taken to remove petitioners to Eswatini or any other country, including but not limited to Costa Rica, and what additional steps, if any, respondents will take in the reasonably foreseeable future to remove petitioner to Eswatini or any other country, including but not limited to Costa Rica. And this is absolute lunacy. I mean, this should get you a taste of what this administration is. It is like so depraved. The court held an evidentiary hearing 4 days later. Respondents, that is the government, produced one witness, Deputy Assistant Director of ICE Enforcement and Removal Operations, Iro. You'll sometimes see Iro on these brown shirts, little lapels, and or whatever, their tactical vests and shit when they're going to scare grandmas. You'll see Iro. Contrary to the court's order, Schultz was not prepared at all. Contrary to the order. So again, the court will always emphasize, like, I ordered you to produce someone who is prepared to discuss this, and you're violating the order. Again, Schultz was not prepared at all to discuss Costa Rica's offer to accept Abrego Garcia as a refugee. Schultz candidly admitted he had not even seen the Costa Rican correspondence to the government about this. Like, this is the guy that, like, everyone knows about the Costa Rica issue, right? This is not like some random country that I'm like, oh yeah, be prepared to talk about every country, including Costa Rica. The reason that in the order it specifies Costa Rica is because this is like an issue that everyone's aware of. Do you get me? Shaughnessy versus United States was the Ellis Island case. Got it. Yeah. Understand. Not Mazai. My bad. Schultz candidly admitted he had not even seen Costa Rica's August 21st, 2025 correspondence, and he had no knowledge about whether respondents had done anything to commence removal proceedings to Costa Rica. Next, as to Uganda, Schultz testified that the respondents had asked Uganda to take Abrego Garcia, but it said no. So they were sending, like, threatening emails to Abrego's counsel saying, like, we're going to send you to African countries. Uganda hadn't said yes. And then they went Eswatini, and Eswatini also said no. As to Eswatini, Schultz testified the respondents had not formally asked them to accept Abrego Garcia until Wednesday night before the evidentiary hearing. So it was two nights, the night of Wednesday, right? You have your term paper due on Friday. The term paper for, like, everything, right? It's the big thing about removing this person, or in the context of your term paper, the entire semester, right? The whole semester has been about this. And you wait until Wednesday night, like, what, within 36 hours of when this hearing takes place, to actually even ask the country that you say you want to remove them to. Quoting from the transcript, so the United States has not asked Eswatini to accept Mr. Abrego until this past Wednesday. Schultz, Your Honor, I didn't know what occurred in, say, September. That was before the notification that Eswatini was the country. I just know that the request was made Wednesday evening to Eswatini. Question, but you have no other information about requests. Schultz, no, Your Honor. Schultz also reported that even though Eswatini said no, the conversations weren't over. Oh, great. So they said no, but the conversations weren't over. Thank you, Schultz. Schultz further confirmed that the night before the hearing, respondents notified Abrego Garcia's counsel that he would now be removed to yet a third African country. Looks like the conversations were over with Eswatini. Ghana. But once the purported designation to Ghana became public, the Ghanaian foreign minister, Sam Okudezeto Ablakwa, immediately announced that Ghana was not accepting Abrego Garcia. He cannot be deported to Ghana, and this position has been directly and unambiguously conveyed to the U.S. authorities. So, like, this is so fucked. They have Costa Rica. They have the Costa Rica letter. They know about it. And they're just inventing countries that have all said no in Africa to fuck with this dude. Schultz ultimately confirmed that he knew of no impediment to remove Abrego Garcia to Costa Rica, including no statement from the government that effectuating such removal would run contrary to U.S. interest. Right? Imagine them be like, no, we can't send this guy to U.S. interest or to Costa Rica. It would be contrary to our foreign policy interests. They would be the kind of government to do that. And it's just defined as U.S. interest. Like, well, Trump is the U.S. interest, and he is very interested in that not occurring. Kill me. I mean, this is Depraved. It's depraved conduct. Anyone can see it. Schultz further attested that he had been told nothing about why respondents had not yet processed Abrego Garcia's removal to Costa Rica. Counsel for Abrego Garcia in turn emphasized that his client's continued detention must be for purposes other than facilitating removal, because if respondents want to remove him to Costa Rica, you will hear no objection from us. They can put him on the next plane to Costa Rica. So at this point, it's possible Abrego Garcia is just like, I'm done with this. I want to be free. Just send me. This is how they chip away and chip away. And so he's like, maybe even resign. Like, yeah, okay, send me to Costa Rica. Separate me from my family. Indeed, in oral arguments, respondents' counsel acknowledged that the only legitimate ground to hold Abrego Garcia was to effectuate removal. It's clear that it's detention for a removal. And yet they had no answers as to why the policymakers eschewed Costa Rica. The best they could do was stipulate that Costa Rica is on the table if Eswatini falls through. The court concluded the hearing by announcing it would reach the Zedvitas claim expeditiously. But before the court could formally rule, respondents notified Abrego Garcia and the court on October 24th, 2025, that they now intended to remove him to yet a fourth African country, Liberia. Liberia evidently agreed to accept Abrego Garcia on a strictly humanitarian and temporary basis, with promises not to persecute, torture, or refoul him. The court convened a status conference about the Liberia notice, during which Abrego Garcia requested one final hearing to address the remaining counts of his petition. The court does not credit respondents' contention that Abrego Garcia had claimed fear of removal to Costa Rica. Abrego counsel admitted he had mistakenly included Costa Rica on a blanket fear assertion that named several other countries. Abrego Garcia also has confirmed in writing and repeatedly through counsel his consent to be removed to Costa Rica without delay. The court credits this evidence. The court convened a status conference after the Liberia notice, during which Abrego Garcia requested one final hearing. Respondents posed no objection and indicated they would separately move for this court to dissolve its temporary prohibition on removing Abrego Garcia from the continental United States. Given that respondents had once illegally removed Abrego Garcia, the court had ordered respondents not to remove him from the United States absent further order. The court also made plain that at any time, respondents could move for dissolution of the injunction if it presented an impediment to expeditious removal. Nonetheless, at points, counsel for respondents tried to blame the injunction as imposing some chimeric obstacle to their removal efforts. This misdirection failed, as the court was always clear that once actual removal was underway, if taken consistently with the INA and due process, the court would dissolve the injunction upon respondents' motion. So these guys are always like fucking lying and saying shit like, oh, it's your fault. You made me do this. You're the reason why this is all fucking up, is because your fucking injunction that is there only and exclusively because you have shown yourselves to be incapable of following the law and the basic contours of due process. Somehow it's the court's fault. In their subsequent filings, respondents justified, this is where they're lying, right? They justified removing Abrego Garcia to Liberia because it was the only state willing to accept him. Who believes that shit? They told the court that Costa Rica does not wish to receive Abrego Garcia any longer, and that Costa Rica would not simply accept Abrego Garcia. Thus, said respondents, they can hardly be at fault for removing petitioner to a country that refuses to accept him. Respondents also attached the sworn declaration of ICE Acting Assistant Director for the Removal Division, Jonathan Cantu. This guy is a piece of work. Just wait till you see what he fucking says. As purported evidence of Costa Rica's change of heart. The Cantu Declaration. This is so fucked up. Oddly, however, respondents submitted their memoranda in the Cantu Declaration under seal. Huh. Odd. And moved to seal the evidentiary hearing entirely. Odd. This represented a sharp departure from their prior practice to seal only that which is necessary to protect diplomatic communications, as typically memorialized in a diplomatic note or memorandum of understanding. Respondents also did not attach any communication from Costa Rica reflecting any rescission or modification of its prior offer to receive Abrego Garcia as a refugee. Does anyone from the chat, I'm watching the chat even though it's not on screen, does anyone from the chat know maybe why they did this? This is odd. So you're like, Costa Rica, they've had a change of heart, and they no longer want to accept Abrego Garcia. Does anyone have any ideas for maybe why they filed under seal? Any thoughts? Why did they do this? Why did they do this wacky thing? Trump threatened tariffs? No. Good guess. That's because it's scary. No. Seriously, guys, it's a pretty simple answer. I'm not moving on till we get a couple more guesses. Because they didn't want Costa Rica to see. Oh, now you're getting closer. Now you're getting closer. Why didn't they want Costa Rica to see? So they could fucking lie, because it was a whole fucking lie. Read this. Abrego Garcia quickly asked the court to make Cantu available for testimony. The court granted the motion over respondents' vigorous objections. The court also unsealed the relevant filings and ordered the respondents and the lawyers to prepare the witness in good faith to answer questions about Costa Rica's willingness to accept Abrego Garcia. At the hearing, it became evident that once again, respondents defied this court's orders. Cantu is the sixth witness whom the court directed respondents to prepare for either deposition or in-court testimony concerning this case. Each witness was either unprepared or defiant in their refusal to answer questions. The court will consider the entire course of conduct when it reaches the motions pending in Abrego 1. They lied. They fucking lied. They simply refused to prepare and produce a witness with knowledge to testify in any meaningful way. Cantu candidly admitted, for example, that he had... Okay. We'll try it again. Cantu candidly admitted, for example, he had no prior involvement in Abrego Garcia's case. He spent 5 minutes preparing to testify. The court says, hey, you've claimed that Costa Rica won't accept Abrego Garcia. They rescinded their offer. Huh, that's weird. Why don't you bring in a witness so that you can actually testify to that shit? They bring in this dipshit, this disgrace, fucking disgrace, like Drogba. It's a disgrace. It's a fucking disgrace. This is like every single, like, imagine this, the whole thing is a disaster. The whole thing is a crime. It's disgraceful. There's so many adjectives, but this part of it, right? You're making a claim now and deciding on like whether or not you should deport this dude to Africa or to some fucking place that he speaks a language where he'll be more comfortable, that actually wants him. And so you're lying and you're frustrating the court for the specific purpose of fucking with this dude. And you didn't have someone with experience at all. He spent 5 minutes. 5 minutes. What other excuse can there be for that other than malicious non-compliance because they hate that this judge is actually imposing the force of law on the government? That you would do this disgusting fucking act? When someone's freedom, they're like, where they're going to be is at stake. As a human being. 5 minutes. Cantu also shared that none of the respondents' attorneys had discussed the order with him or shown him its contents. They didn't show the dude the order about getting him to testify. They picked up a dude, brought him to court with no notice, gave him 5 minutes to prepare, and didn't even show them the order. And this guy showed up to testify. Cantu, the ice guy, didn't understand the purpose of his testimony. Then at the hearing, respondents showcased Cantu's ignorance, that is the government itself, about the content of the declaration pertaining to Costa Rica. Because this guy, who is this guy, right? This guy wrote the declaration about Costa Rica. As the pointed questions of respondents' counsel made clear, Cantu's lack of knowledge was planned and purposeful. What is Zinnes saying here? The government is purposely trying to fuck with the court. This is the government's own lawyer. So paragraph 4, the final sentence of the Cantu Declaration. Do you see where it says the word certain understandings? I found it. Yes, I do. I see it. What are the certain understandings referenced in the last sentence? I don't know. Counsel, what are the contingencies referenced in the last sentence? I don't know. Counsel, what are the interim... This is government counsel, okay? This is the government asking these questions of their own witness. What are the interim developments referenced in paragraph 5? I don't know. The government counsel at sidebar with the court saying, I'll just say I told you this was exactly what was going to happen regarding the witness's ignorance on Costa Rica as a viable country of removal. So this motherfucker is telling the court, I told you, you try to bring someone in, they're just going to send me someone who doesn't know anything. The Department of Justice of the United States of America. That's your DOJ. That's your government. Talking to the court like that. Who's talking about Collins? You best not be fucking tempting me with a good time. You best not be tempting me. We don't got a trumper and waiting in the wings, do we? You know I'm always looking for that shit. Put me in, coach. What recourse does Garcia have? In cases like this, aggravated party is usually set for life. Is that true? No, very little. Very, very little. Ultimately, respondents' calculated effort to take Costa Rica off the table backfired. Look, it is insanity, right? What you're about to read. So everything was bad enough. Within 24 hours, Costa Rica, through Minister Zamora Cordero, communicated to multiple news sources that its offer to grant Abrego Garcia residence and refugee status is and always has been firm, unwavering, and unconditional. They fucking lied. Why did they do it under seal? Because they're liars. Because they didn't want Costa Rica to see that they're lying about Costa Rica. All these people should be held in fucking contempt. If we had any fucking justice, if we had a Supreme Court with an actual commitment to the rule of law, instead of frustrating the judiciary's attempt to hold to account the excesses and illegal conduct of the administration, we should have already had rulings. The fact that they're fucking around with the Boasberg shit and just fucking around with Boasberg when that was obvious contempt and forcing him to go through this song and dance, that's already insane and bizarre. Like, this entire shit, people should be in jail for this. People should be losing their licenses to practice law for this. Zamora Cordero confirming that Costa Rica's offer is the official position of the government. Respondents have sat mum since. So you just fucking lied. You lied. You brought in people who don't know shit. When your lie was called out, you haven't said anything. Despite this tortured history, Abrego Garcia's arguments in favor of release are quite simple. He contends that there's no authority because there's no final order of removal. Right? How can you say that you're ordering me removed and that's why you're detaining me, if you haven't actually ordered me removed? Seems like almost like a circular. There's a problem. There's some circularity there, or I don't know, some gating concerns, some threshold issues of purporting to detain me to be removed when you haven't ordered me removed. Respondent's central retort is that we lack jurisdiction. Biggest, fucking plot twist in the whole world. It's another day in court and another time in which the Trump administration claims that there's no jurisdiction of the court to actually do anything. So who's surprised by this? That's your tax dollars hard at work in every case, on all arguments, always arguing the court lacks jurisdiction, unless for whatever reason they need to go to court. Respondents contend the court lacks subject matter jurisdiction. So there are provisions of the INA that limit the district court's ability to actually review determinations as to orders of removal. And they want to channel everything through the appeals process of the the Executive Office for Immigration Review, and then ultimately to the circuit courts on a very like kind of deferential basis. So generally, district courts don't have subject matter jurisdiction. They've been stripped of jurisdiction to hear the substance of a lot of these immigration decisions, and they have to be kind of channeled through a particular procedural pathway. So that's what they're talking about here. This provision of law bars the court from hearing three discrete kinds of claims arising from an action of the AG to commence proceedings, adjudicate cases, or execute removal orders. So those three things. So the question is going to be, is this a case to commence proceedings? Is it a case to adjudicate cases? Or is it a case arising from the execution of removal order? Abrego Garcia's petition does not challenge the commencement of proceedings or adjudication of any case. Accordingly, the only conceivable argument for which the Section 1252G strips the court of jurisdiction is that the petition challenges the execution of a removal order. But Abrego Garcia does not challenge the execution of a removal order. Instead, he contends that his detention is unlawful and not reasonably foreseeable because he is held in absence of a removal order. Thus, Abrego Garcia's request for immediate release cannot touch upon the execution of a removal order if no such order exists. By the way, and here they're citing case law that says, yeah, if you don't have an order removal, then we don't have a jurisdictional bar here. For similar reasons, these other bars don't, or these other statutes don't bar the court's power to adjudicate the petition. These various statutes were enacted to eliminate habeas review over all final. Thank you so much for the gifted memberships, Pasreka. The order does not exist, no. But again, Abrego Garcia is not challenging a final order of removal via habeas or anything. He argues instead that his detention lacks lawful authority because there is no such order. In this important respect, the question presented by the habeas petition is whether there is a removal order at all, which is different than whether an extant removal order is lawful, right? So not challenging the legality of or the enforcement of a removal order, but the existence of the detention of a human being in the absence of a removal order, purportedly on the basis of removal, when there is no removal order. For these reasons, the court retains jurisdiction to hear Abrego Garcia's argument because none concern the review of a removal order. The court next turns to the merits of Abrego Garcia's grounds for relief. The two remaining jurisdictional arguments from the government focus on the subsidiary due process challenge to the respondents concerning third country removals. The court need not reach them because it grants the petition on other grounds. So we're not going to reach these other areas so we don't have to consider our jurisdiction there because we're going to grant it on one area where we definitely do have jurisdiction. Merits of the petition, he says that there is no order of removal. Although the proceedings until now have not squarely depended on adjudicating this most basic fact, that time has come. To understand why, the court first explains what a removal order is and is not as a matter of law. And next, why the court finds that no such order exists for Abrego Garcia. Last, the court discusses why the absence of such order compels his release. An order of removal is the vehicle by which the executive branch retains the power conferred by Congress to remove a non-citizen from the United States against his will. Such power is tantamount to an order of deportation, defined as, quote, an order concluding that the non-citizen is deportable and or ordering deportation. An order of removal must be explicit in its directive that a non-citizen is to be removed to an identified country or countries. Further, whereas here an immigration judge issues a decision granting a non-citizen's application for withholding, the decision must include an explicit order of removal. Right? So think about this, right? Why would it make sense to order withholding of removal if there's no removal order? And so you're supposed to, as a matter of immigration law, if you're an immigration judge, do both. Because you're supposed to order the removal and then withhold removal. That's what you're supposed to do. But they're different orders. Very important. This is so because when a non-citizen receives protection from removal to an identified country, the predicate removal order takes on special importance. As Judge Wilkinson ably explained in Kwambu versus Barr, the existence of a removal order is fundamental to determining whether and to where a non-citizen may be removed. And understand, I keep going back to that Rob Moore conversation. This ignorant motherfucker said that there was a general removal order to Abrego Garcia. I debated with dipshit MAGA losers who don't know anything about the INA or indeed immigration law at all, or immigration at all. And they were like, oh yeah, he was ordered removed. He was ordered removed. He wasn't. And you'll see why. That was a mistake from the IJ. First, as a matter of simple logic, but that, by the way, that IJ, under the executive branch, under Bill Barr, under Trump, term 1. First, as a matter of simple logic, in order to withhold removal, there must first be an order of removal that can be withheld. Second, because a non-citizen protected by an order of withholding may still be removed to a willing third country, the IJ must issue a final order of removal to authorize DHS to effectuate such a removal if a third country is identified. And this was getting into the issue where people were like, fine, if you can't send them to El Salvador, you know what we should do? We should immediately grab them and put them somewhere else. And the whole point is, well, you need a removal order to a particular place because he could raise claims, defenses to anywhere you want to send him. So you're probably going to be able to find some place you can send him for sure that's either willing to accept him or something, right? But you certainly can't just say, oh, get him out of Sikat and just throw him across the border somewhere else. Because that would not be in keeping with the actual order that you need to find, because, and also due process, because this person is entitled to raise those defenses to particular places you want to send them, right? The Convention Against Torture, you can't just say, okay, we will try to El Salvador, so we'll send him to another place that's going to discriminate or persecute him on the basis of one of the protected categories for purposes of asylum or refoulement or Convention Against Torture or whatever. Next factual finding by the court: no order of removal exists for Abrego Garcia. No such order of removal exists for Abrego Garcia. When Abrego Garcia was first wrongly expelled to El Salvador, the court struggled to understand the legal authority for even seizing him in the first place. At the first hearing in Abrego 1, the court inquired of respondent's counsel. The court, I want to ask, though, the very specific question: if there is a final order of removal, what document got this process started? There is no warrant for his arrest by an order of removal. There is no statement of probable cause. There's no charge. There's no report that says that anyone saw Mr. Abrego Garcia doing anything illegal or criminal. So what is the actual document that gives these officers the authority to start this process? Counsel for the government. That is not in the record, and the government has not put that into the record, and that's the best I can do. The court continued to press counsel about the existence of a removal order and was told plainly that none can be found. Okay, so if there's a Title 8 removal order, there would be an order of removal that's being executed. And we don't have one for Mr. Abrego Garcia, right? Do you have that order? Is it in the record? Counsel, I do not have that order. It's not in the record. Since that time, respondents have never produced an order of removal, despite Abrego Garcia hinging much of his jurisdictional legal arguments on it. I don't know if this guy Grant Withers, do you want to jump into the Discord? Seems like you're talking about shit you don't know. And just, you can always tell by these people like fucking just Google something very quickly or ask ChatGPT. I really hope that we don't have another scared motherfucker. Not sure what Discord is. Oh, okay. Very cool. Very cute. Boomer or troll. Indeed, respondents twice sponsored the testimony of ICE officials, whose job it is to effectuate removal orders and who candidly admitted to having never seen one for Abrego Garcia. Based upon your many years of experience, you described to us, you know what a final order of removal looks like. Right, sir? Cantu, I do. And have you seen a final order of removal in regard to Mr. Abrego Garcia? Cantu, I have not. Asking the ICE removal operations guy, Thomas Giles, or I don't fucking know his name. You have not seen the final order of removal, have you, sir? Giles. What do you mean by that? Oh, you have not seen a piece of paper that represents the final order of removal? No, I have not. Based on this, the court concludes that no order of removal exists. Additionally, the ICE immigration detainer for Abrego Garcia dated June 6 and first being part of the record in Abrego 1 corroborates that no final order of removal exists. The detainer includes a pre-printed section articulating that probable cause for believing the subject is a removable individual because of either the existence of a final order or the pendency of ongoing removal proceedings. The ICE officer checked the box for pendency, even though there was nothing pending at the time. More to the point, the ICE officer did not check that detention was based on the existence of a final order of removal. So there's other evidence that suggests there was no final order of removal, including the government's own representations. Respondents do not contend otherwise. Instead, they urge the court to construe the October 10th withholding decision as an implied order of removal, or one that exists by operation of law. They essentially argue that because an IJ would not grant withholding of removal absent a valid order of removal, then the court can read into the withholding decision the existence of a removal order. While this argument has some intuitive appeal, it belies both the facts of this case and the long-established precedent which commands against collapsing two legally distinct orders, removal and withholding of removal, into one. The October 10th withholding decision is unambiguously not an order of removal. It does not order Abrego Garcia removed to any country or designate removal to alternative countries, as required under the INA, right? You're not allowed to have a order of removal that's just general. It needs to be specified to a particular place. Nowhere in the October 10th withholding decision does the IJ order Abrego Garcia removed to El Salvador or anywhere else. Nor can the court conclude legally that a removal order is implicit in the October 10th withholding decision, as respondents urge. The Fourth Circuit has made clear, when an IJ grants withholding of removal, an explicit order of removal must be included in the decision that identifies the country to which the non-citizen may be removed and alternative countries. It is this explicit designation that authorizes DHS to effectuate such a removal if a third country is identified. Because the October 10th withholding decision does not order Abrego removed to any country, it is simply not an order of removal, right? So understand the logic of it. Here, I'll give you literal logic. Oh, shit. Okay. Wait, fuck. Right? This is my logic. The law, INA, requires for something to be a valid, a lawful order of removal, it is legally required to specify a country at a bare minimum, right? To specify country. So think of it like this. If no country specified, then not order of removal by law. So just follow that here. Did this order, putting aside the fact that it doesn't state that it orders him removed, you just put that aside for a second. Does it specify a country? Well, if it doesn't specify a country, it's not a removal order. It simply is not an order of removal. Moreover, to conclude, as respondents suggest, that the withholding order is also an order of removal would contravene well-established Supreme Court precedent directing otherwise. Consider Nasrallah versus Barr. There, the court held that for jurisdictional purposes under the INA, a final order of removal cannot merge with the withholding order, right? The Nasrallah court reasoned that withholding relief under the Convention Against Torture cannot be construed as a final order of removal because that withholding order itself does not conclude that the non-citizen is deportable or ordering deportation. Rather, a withholding order means only that notwithstanding the order of removal, the non-citizen may not be removed to the designated country of removal, at least until the conditions change. So we have SCOTUS precedent saying that they're different things. The following year, the Supreme Court was called to answer, among other questions, whether an order of removal becomes final at the point of the removal order issues, or later when the non-citizen's withholding only proceeding concludes. The court held the former because removal orders and withholding only proceedings addressed two distinct questions. As a result, they end in two separate orders. This is the Supreme Court of the United States, as recently as 4 years ago, saying these are two orders, very separate things, separate. And the finality of the order of removal does not depend in any way on the outcome of the withholding only proceedings. So putting aside the facts of this case, here, additionally, we said there are two different things. Just a few months ago, the Supreme Court in Riley versus Bondi reaffirmed the lessons taught by Nasrallah and Guzman Chavez, in concluding that an order from the Board of Immigration Appeals that vacated the grant of cat relief was not a final order of removal. The Riley court emphasized that the Board of Immigration Appeals order simply did not affect the validity of a previously issued order of removal. Because removal orders remain legally distinct from subsequent denials of relief, the final removal order does not depend on the withholding proceeding. And this is used to the immigrants' detriment in these cases. But now it's to their benefit, right? This is so even though the construction invites procedural difficulties in streamlined appellate review of both the removal order and the withholding decision. Read together, these Supreme Court precedents foreclose the respondent's implicit removal order theory. Each confirms that an order of removal retains separate legal vitality. It must be an order concluding the non-citizen is deportable or ordering deportation. It must also identify, by law, right, the country or countries to which the non-citizen is ordered removed. Absent an order to this effect, the court cannot simply infer that the withholding decision does the trick, as removability and withholding relief are distinct. For the same reason, it rejects their procedural history. Because no order of removal exists, the court turns next to why you have to set him free. And we can skip a little bit of this, but essentially, if you're not about to remove him because there's no order of removal, how do you continue to maintain him? On what basis? Then we go, in addition to this, said Vitus. Because respondents continue to detain Abrego Garcia solely for the purpose of effectuating a third country removal, but lack any authority to effectuate removal, his detention must end. And then additionally, even if, right, what's going on were otherwise. It seems constantly infirm under Zedvitus. It's an imprecise fit because respondents have no lawful authority to hold him, and in Zedvitus they did have lawful authority. There, the Supreme Court was called upon to set the due process limits of prolonged detention under a separate statute, and they read it as permitting. They didn't read it as permitting indefinite detention because it would raise serious constitutional concerns. So the Zedvitus court grounded its decision in 3 principles of special relevance: that you can only detain a non-citizen pursuant to statutory authority. You don't have like a general authority to detain people under the INA, and with the purpose to effectuate lawful removal. Although this principle may seem self-evident, it bears emphasizing for Abrego Garcia, as he has been held without a removal order and without lawful authority for months. He was tortured without a removal order. He was removed without a removal order. He was removed in violation of the withholding order. And he's been stuck in detention ever since, with some, like a 3-day exception. Second, detention to effectuate third country removal can only be for the period reasonably necessary to secure such removal. The presumptive 6-month period provides an important limitation, but the presumption can be rebutted when you say that the removal is not reasonably foreseeable, and it's not reasonably foreseeable when you don't have an order of removal. And we can skip nearby to the end. Respondent serially notified Abrego Garcia while he sat in ICE custody of his expulsion to Uganda, then Eswatini, then Ghana, but none of these countries were ever viable options, and at least 2 had not even been asked to take Abrego Garcia before respondents claimed supposed removal to each. At the same time, respondents did not take any steps to remove him to the country which had offered to take him. This inexplicable reluctance seems at odds with continued detention for purposes of third country removal, so the court acts repeatedly during oral arguments to address the disconnect. These orders were ignored without justification. Respondents instead found a 4th African country, Liberia. This time, when the court sought information about Liberia and Costa Rica so to fairly assess the validity of Abrego Garcia's claims, respondents did not just stonewall. They affirmatively misled the tribunal. They lied. They announced that Liberia is the only viable removal option because Costa Rica does not wish to receive him, and that Costa Rica will no longer accept the transfer of him. But Costa Rica had never wavered in its commitment to receive Abrego Garcia, just as Abrego Garcia never wavered in his commitment to resettle there. This evidently remained an inconvenient truth for respondents, but more to the point, respondents' persistent refusal to acknowledge Costa Rica as a viable removal option, their threats to send Abrego Garcia to African countries that never agreed to take him, and their misrepresentations to the court that Liberia is now the only country, all reflect that whatever purpose was behind his detention, it was not for the basic purpose of a timely third country removal. And there's a really good line here somewhere. Where is it? It's this line. And this is the part I'll leave you with this opinion, and then we can talk about some other stuff. And if there's someone who wants to hop in, please do so. With these principles of Zedvitus as a guidance, the court turns to Abrego Garcia's continued detention. First, because respondents had no statutory authority to remove Abrego Garcia to third country absent a removal order, his removal cannot be considered reasonably foreseeable, imminent, or consistent with due process. And this is the line that I love. Although respondents may eventually get it right, they have not as of today. Thus, Abrego Garcia's detention for the stated purpose cannot continue. So they might eventually have a basis, and I think that they might, and probably will, to remove Abrego Garcia. But they haven't even, done the basics, man. And they just keep lying and getting themselves into trouble. So even if you're a Trump supporter, even if you're one of these MAGA clowns, these disgusting freaks of nature that show up to my chat or go into my replies and then are too pussy to come in and have a debate, you got to be disappointed with the incompetence of the administration, not just on this issue, on Comey, on Letitia James, on all your other pretend fucking cases you care about, on Epstein, right? It's so delicious watching them seethe. Because all the shit that they claim to care about and that they endlessly retweet all the bullshit from these bullshit artists that they follow. They're not going to get it, and even if they did, it wouldn't make their lives happy. But the fact that they elected somebody to be efficient and drain the swamp and to get rid of all these migrants and shit and people who are here against the law, and they can't even get people to adequately and competently remove someone who is almost certainly removable. It's delicious. Of the entire saga, right? Obviously, horrific shit, depraved conduct. I believe that we should give Abrego Garcia minimum $20 million. U.S. government should make a fund for all the people that they've deprived of rights in violation of law. They should immediately grant citizenship to Abrego Garcia and anyone who wants it, who's been deprived of their rights knowingly by the administration, which is probably hundreds of people, as penance for the crimes that our country has engaged in by doing this kind of bullshit. But it's nice to know that even if he doesn't have some measure of justice, that MAGA can continue to rely on their bullshit president and their sycophantic lackeys being completely and utterly incompetent. And with that, any questions? Questions, my guys. Questions. Oh yeah, they paid that traitor Ashley Babbitt. Sick. Very sick. Oh, quick little Drew Pavlu. Drew Pavlu moment. Moment of Zen. So Will Stansel, if you guys remember, this is the liberal commentator who Mecha Hitler / Grok said should be graped to death. Everyone shits on Will Stansel. I don't know why. But Drew is correctly calling out Drew. This dude's whole shtick for years was that he was standing up to liberal democracy against regimes like China. But suddenly he's out here going, it's illegal to say the president should be in jail, with reference to the Newsom tweet where he's talking about this. But by the way, I totally agree with Newsom. I think it's based, all these people should be in jail. And Hegseth and Trump specifically should be jailed for murder and conspiracy to commit murder. And they should be, in jail for the rest of their lives. That's just to start, right? But and none of that is inciting violence whatsoever. But Drew says the post is inciting violence against the president. And then Drew's like, when did I say Newsom's post should be illegal or banned? I simply criticized it. Incitement is a crime, dude. You accuse them of doing something illegal, bro. And then helpfully, Nick from the internet, Pisco, he didn't say the word illegal. Checkmate, libtard. Oh my god, you sound like Hitler, you freak. When is this guy gonna man up for a convo? Anyway, that's what we got. I think the Abrego stuff will take longer than Trump's term to resolve. No, they'll probably be able to effectuate a deportation before his term ends. We'll see, though. That's my bet. Because I think they'll prioritize it, so they'll give him his this whatever last vestiges of due process he has. They'll probably send him to Costa Rica. He might even voluntarily after he's released, which I think is, they were supposed to email Chambers by like 5 today. He might even just voluntarily leave to Costa Rica, because who the fuck wants to be like kept in jail and have such uncertainty? Like, he probably wants to move on with his life, which I understand. Like, no one can make that decision but him. And then if he wants to come back when we have a Democratic president, we are going to strenuously advocate for naturalization, immediate by law. Wait, I was going to say something else. Debate board. If you want to talk about stuff, you got to come on Voice. You just have these like long, incorrect, rambling fucking comments in all of my YouTube videos. They're all just unhinged and incorrect and silly and like just dumb shit. Like, you're literally one of the dumbest people who shows up to the chat. So if you want me to like address shit you're saying other than like when I choose to, just come on stream so we can all hear you and make your arguments actually, and not just rely on AI. I noticed that, by the way, a lot of your posts are AI. Pathetic. Grant is NBC. Oh, sick. Do we have someone? Awesome. Let's do it. Let's do it. Oh, I got a message from Box Loner. Sick. Maybe we'll get some content. Fucking content. Wait, why are there so many people there? I'm not going where all those people there. Does he want to be... Someone tell me if he wants to be brought in. You want to be brought in? Grant, you want to be brought in? Okay, sick. Got it. We'll bring you in. Yo, what up, man?
Can you hear me?
Yeah, wait, just let me check your levels real quick.
I'm sorry. Can you hear me though?
Yeah, I can hear you. Just can you keep talking just so I can check your levels? Just keep talking.
Yeah,
And-
sorry. I was just I'm trying to not just check the levels, but check the feedback. I think
Yeah,
that-
you have to pause the video, man. You got to pause the video. So you can't talk to me through YouTube. You have to talk to me through Discord.
Yeah, I got you, bro. I'm just saying, like, it's not just pause the video, but I think I need to
Check your inputs, your audio
thing
inputs.
here as well.
We can hear you. Someone tell this guy or in
But
chat.
yeah, in any case, I mean, yeah, if they can hear me live, I don't want to.
You need to be able to hear me though. Can you hear me?
too much dead air or anything. You're just bringing me out.
No, you need to be able to hear me.
It
Hey,
sounds
dude.
like,
Hey, dude.
Sounds like they maybe can hear me. Meat is talking, I guess, right now. So
You-
yeah.
you-
Anyway, I mean, so I guess is he trying?
Okay. Hey, stop. You need to be able to hear me to have a conversation, dude. All right, I'm gonna unmute you. You need to be able to.
Down?
You need to be able to hear me. Can you hear me? Hello? Testing, testing. 1, 2, 3. Hello, hello, hello.
Yeah, sorry, man. I heard you're testing 1, 2, 3, but nothing before that.
Okay, you can hear me now? I don't like how long it's taking for you to respond. It suggests to me that
I
you're...
can, in fact. Yep, I do have some feedback, but don't worry about it.
No, because you're
Yeah, sorry about
listening. You're listening through the YouTube video. That's boomer shit. Are you listening through the YouTube video? That's not going to work. You need to listen to through Discord.
I hear you. I understand. It is boomer shit. Yeah. Okay. All right. I got you. All right.
Is this a troll, dude? We can't talk through the YouTube. You understand? Because there's a delay. You need to talk through Discord.
I get it. I'm trying to work on it right now. I don't know why your Discord is not giving me voice though.
We can hear you. I don't know what you mean. It's giving you, so you're not hearing me. Check your audio inputs. Where are you using Discord on? On your phone or something? Yeah, go. I guess maybe steal him, Sharpie, but he might not be able to hear you. That's why, like.
No, it's on actual.
Okay, if you're listening to me, dude, like, you got to go to the settings on Discord and user settings. If you go to user settings, it'll say voice. It'll have input and output. And you need to pick for your output device, whatever the fuck it is that you use. I swear these people will be the death of me. You love this? I do want to bother with it because he sounds like an actual fucking conservative. I haven't been able to get a fucking red-blooded conservative in this fucking shithole. I swear too much these days. In a long time. I hear you. I thought he was fucking with me. Like, I hear you. Yeah, I know. It's boomer shit. You just gotta change your audio output device. Okay, I'm gonna try. I'm gonna try to bring you back. Testing. Can you hear me?
I can hear you.
Hey, there we go. What up, brother? How you doing? Thanks that we got that squared away.
I'm not doing that super great today, but I won't bore you with the details. But I mean,
I'm sorry to hear that.
You guys were going over the Garcia thing. It is minorly interesting at the very least.
All right, tell me your thoughts. What would you think?
Well, so initially, I would just say, I mean, like I caught you maybe halfway through here. It looks like they did not do a formal order of removal through a court, so I'm guessing that they were trying to do either an expedited order of removal and maybe even just literally just him just saying, get this guy out of the country and not even writing it down. I'm not sure what the legalities there are and everything. I don't know what exactly they're looking at, but I'm guessing that's probably what's going on here. And then the court is saying, well, we didn't get a court order of removal, so we got to go through that procedure. Is that basically what's happening there, you think?
Part of it is true, but not all of it. So it's actually not courts that give orders of removal. Okay, it's weird because they're called immigration courts, but they're executive. They're executive.
Bureaucrats, yeah.
Yeah, so it's the immigration court under the Department of Justice. And what the administration is position is that they're allowed to send him out, but the INA, the Immigration Nationality Act, which is like the basic framework of our immigration laws, they like put requirements on orders of removal. They can't just be, they have to give orders of removal to effectuate removal. And there are some instances in which you can do like turnaways without orders of removal, and that will happen at the border before they've entered the country. But if you're in the country, even pursuant to expedited removal, they are required to give, there's a piece of paper that will specify that there's a final order of removal from the country. Now, does it have the same kind of procedural protections that one that's not done through expedited removal? No, but they don't have the same kinds of hearings that you get when you're subject to expedited removal. But you still need to have a final order of removal, and there's nothing here for Abrego.
Right. So everybody keeps saying that there's nothing there, but something actually caused the internal mechanism of the actual ICE people had to go out and do something. Like in general, people in the executive branch don't just like get off their ass and do something over nothing. So was there is this court alleging that there was like some sort of an internal order that was just based on Mr. Garcia being in incarceration or something, or he was already incarcerated, and then they were just like, well, get this guy out of here, and they managed to get ICE off their behinds, and ICE went and tried to deport him without doing any of this legalities? Or is that what the court is trying to say that is happening, or what?
Do you want the court's perspective or my perspective?
Either which way.
I'll do both. So I'll start with the court's perspective. The court's perspective is we have no clue. That's what we're asking the government for, and they're not telling us the answer. Like, the court is asking these questions, like, what is the basis for you to remove this person? Why have you seized him? Under what authorities have you seized him? There was a previous illegal deportation to this Sicat prison in El Salvador. And
yeah, I remember.
The court is like, the very questions you're asking, like what brought about this thing, are the things that the administration is stonewalling the court on. So the court's perspective is, listen, you're claiming to detain this person based solely on a removal that you're trying to effectuate. And this removal, you're not citing any authority other than Title 8 authorities. Title 8 is like the immigration title authorities. And therefore, that's what the basis under which I'm judging it. But those kinds of questions, to the extent that they're unanswered because the government is not forthcoming with what's going on. Now, I can give you the real answer. The real answer is the administration was trying to stretch its legs and apply its obscene, due process-free interpretation of the Alien Enemies Act and other related statutes. And all they did was, I'm sure they grabbed a list of people who they felt they could link to gangs, and in Mr. Abrego's case, I think not in a way that is convincing at all to anybody. And they just illegally rendered these people under no authority. Like it wasn't an authorized capture and deportation. They just grabbed him without any authority and removed him to a place specifically where he was not supposed to go. And so the truth is, right, like they were just looking to deprive people of due process and send them out of the country without having any court fucking with them. And they had the planes ready to go. And they specifically had these plans. And there's whistleblowers now that are coming out and saying, yeah, and we're not going to let the court stop us. If there's a court order, I don't want you guys to listen to it. Like, it is just that simple. That's what actually happened.
Right, I hear what you're saying. So, but let's put this in a more generous light, if you don't mind. Do you mind me putting it in a more generous light?
I'm curious to hear you try.
Yeah, so it's very simple. Trump comes in, he finds himself in a bureaucratic mess of tangled up laws that have been imposed to where they can't deport people. Basically, the whole immigration system is gummed up to where you can't deport people. That's what it is really. There's some people that you can deport, and which they do, and they say, oh, well, now we can deport people. But then there's just a whole big list of people that you just can't deport, whatever they're scared of going to this country, they're gay, they're trans, whatever it is. You can't deport them basically. And so he comes in, he finds this, he's tangled up in all this mess. But he's supposedly supposed to be the one that has final authority over who can be and who cannot be in the country and who is allowed in, who is allowed out. That's his executive role, supposedly. So he looks at it and he says, okay, so there's another law over here that's about what you just said there with the enemies and something other there. Basically, we're talking about designated terrorist groups. So what they're trying to do is they're trying to keep it under wraps where it's like, okay, we're designating them as terrorist groups and we're acting under the authority of this thing over here, which we don't actually have to tell the courts. And so we're not going to tell the courts. We don't care about the court because they're not involved in this procedure, most likely at all. I'm just guessing, right? Because it's just him. It's just under that statute, probably the courts aren't involved hardly at all, most likely, is what I'm guessing, right?
Yeah, none of that's true.
Okay, well, go ahead. All right.
Yeah, so this is why it's not true. So first off, it doesn't relate to terrorist designated organizations. The Alien Enemies Act is about countries with which, specifically countries that America is at war with or is about to be invaded by, and it doesn't relate to like non-state actors. So it's not terrorist designated organizations. It's specifically countries. Number one. Number two. They didn't purport to apply the Alien Enemies Act directly to him. He got caught up in a bunch of Alien Enemies Act deportations and was like kind of on the same places, in the same planes as some of these people. But he wasn't.
Well, hang on. You're saying that they didn't purport to. They don't necessarily have to. And so they just didn't bother to. That's a more generous interpretation. But go ahead. All right.
They didn't purport to means they don't claim it. And the reason they don't claim it, do you want to know why?
Well, go ahead. All right.
Is because he's not a citizen. Where do you think he's a citizen of?
I forget exactly where it was he was a citizen of, but go ahead.
Right. Where are you getting this information, by the way? Because I'll tell you where he is from and why everything you said was like essentially wrong. I'm fascinated because like, all right, he's not a citizen from Venezuela. He's a Salvadorian citizen from El Salvador, and the Trump administration is great friends with El Salvador. You realize that?
Okay, great.
It's this guy Bukele. Do you know Bukele, this dipshit loser dictator guy who every right winger loves?
I'm not familiar with him. I don't think.
So
Bukele.
Is he the
guy that Ellen Page famously did an interview with? Probably not.
Ellen Page?
I don't remember. Elliot Page now, whatever.
You think Elliot Page did an interview with Bukele?
Well, he did an interview. She did an interview with.
What are you talking about?
South American guy. I don't.
You're a fucking troll. Are you trolling me?
No, it's not a troll. She was down there asking him about things, and I believe it was actually specifically on trans rights things.
Oh my God!
She came out as trans. Yeah. Well, what are you oh my God about? I mean, it's not that big of a deal. But fine, okay, it's not that guy or whatever. It's somebody else in El Salvador. Go ahead.
I don't know what to go. I think that you're a troll.
I'm not trolling, bro. I mean, like I do have certain mental issues that do a lot of times cause people to think that I'm trolling them. I'm not.
They cause it.
But I do not. I'm not actually trolling you right now. No.
You have mental issues that cause people to think that you're trolling them?
Yes, actually, quite literally, but they do.
What are your mental issues, if you don't mind me asking? Or do you mind?
I don't mind asking at all. It's schizoid personality disorder. Most likely I have ADHD, which is just now being a little bit released from taking some medication a little while back.
Okay. Well, I'll just let you know that the Alien Enemies Act doesn't apply to Abrego Garcia because he's not from a country that even the administration claims is invading us or is at war with us or anything like that. He's from El Salvador, which is an ally country of the administration. And furthermore, like, the Alien Enemies Act does have judicial review, as even a unanimous Supreme Court has said. Like, you couldn't, and imagine how horrible it would be if you just had a specific form of deportation that was completely.
No, I understand what you're saying. I get you. I understand. I got you. You don't have to go down that route. I understand. But I would say that it probably is judicially reviewable, if it is, through a different mechanism than the one that's currently being done, if I had to take a wild guess. Is that correct?
Well, the mechanism that they used was not doing it at all. It was just like no court. Just grab the people, put them on planes, and get them the fuck out. I mean, that's all they did. They didn't have any.
You're talking about judicial review of that action having already been taken. That would be
no, I'm talking about
after the fact.
I'm talking about pre-deprivation action in the courts.
Which I understand, yeah, and there probably is none for pre-action like that, right? Because, I mean, like in the Alien Enemies Act, it's not going to be like, oh, well, the president has to go to court, and then the court will decide whether or not the president can deport a citizen or native of an enemy nation, right? It's not going to be that. It's the president deports them, and then maybe, possibly, the person files a court case, and then it's subject to judicial review, right?
No. So the court
Really?
the court has said that not only do you get judicial review about whether the preconditions are there, right? Like, you couldn't just say, we're at war with Canada, and therefore I can deport. I understand what the Alien Enemies Act lets you do. It lets you deport any citizen from that country, regardless any citizen who's a non-citizen of the United States, regardless of the reason. You just need to say, oh, you're from that country that we're at war with, we can send you out. So the court has review to see whether or not, A, the preconditions are met to invoke it, and B, whether the person who's being alleged to be from that country is actually from that country and subject to the, whatever declaration is invoking the Alien Enemies Act. So
okay,
yeah, there is, and if it were otherwise, they could just pick up anyone they wanted and throw them on a plane. Yeah, and be like, oh, you're from Venezuela, we'll send you there, but it's not, just like his political enemies.
Yeah, I hear what you're saying, but but to be very clear though, what is the actual mechanism that if they were using this, and if they were using this maybe in secret because they didn't manage to tell anybody, they didn't actually tell anybody, right?
Huh?
They're still not telling the court right now that they're using this act, right? We're hypothesizing that they're using this act.
What I'm trying to tell you is they didn't purport, by which I mean they didn't claim to use this for Abrego Garcia, because he's, of course, it's not applicable to him. They just picked him up and deported him without any authority whatsoever. And now they're
giving a more generous interpretation here. I'm just saying, generous.
Why are you giving a generous interpretation? Why are you doing that?
Well, I do it because A, I support Trump, and B, just because also, I mean, just we're looking at it, we're trying to figure out what the administration of the United States is doing. Usually they act with at least some lawyers backing them. Like, usually they have some lawyers coming to them and
they have some stooges saying, "Oh, this is all legal," but right. Any administration is gonna like have some stooge lawyer to be like, "Yeah, well, we're not breaking the law." But in this case, by the way, they admitted they broke the law. That's what's so funny, is that the administration literally, and then they fired the guy who said that initially, even though later on in the Supreme Court they admitted that they did it against the law. So what's funny is, like, in this specific case, it is the most clear example of very obvious law breaking to which the administration copped, including at the highest level, and then fired the person who initially made that very obvious and true and undeniable claim, which is that they broke the law. Like, there's no way around it.
Which law did they break? I mean, I missed this part of your thing. I was trying to join into Discord.
Many provisions of law, including the Due Process Clause of the Fifth Amendment of the Constitution of the United States, including the Immigration Nationality Act, including the international treaties that we've incorporated into U.S. law.
Let's just say that you're right. What's the remedy for that?
Well, the remedy was to facilitate his return to America, and that's what the Supreme Court ordered. And the Trump administration, refused to follow that order for the longest time, and then paroled him into the country to charge him with some crazy theory. and then when he got bail on that charge, they just tried to deport him to like Africa. But like it didn't make sense because like why'd you bring him back to charge him just to deport him? So they're all over the place. They make no sense. And so you trying to give like a good reason for why they would do this, it's futile. It's corrupt. It's vicious, and you're not going to be able to defend it just because you like Trump. I mean, why would you do that?
I mean, I
Trump
thought
sucks.
I thought you literally just told Chad, I think right before I joined, you said that you think eventually they're going to have a case and they're going to deport him, right?
Yeah. Well, yeah, I think that there's a basis to remove him, but that's not eventually, but doing the right way.
Which I totally hear what you're saying. And so from their perspective, all you're doing is dragging your feet, wasting time, wasting millions of dollars over something due process. You think that Thomas Jefferson really wanted him in the country or something, whatever.
What does Thomas?
Way it is.
No, I mean, like, I don't know what the fuck you're talking about.
So
you're like yada 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 due process yada yada yada. You're like, what? Aren't you an American? Don't you have pride in your country? You fucking like
I do, but
boomer.
I
you
do
boomer
not
fuck.
agree with just wasting the government's time.
Oh really?
I don't actually agree. With
why even have trials, dude? We're just wasting the government's time. We know you're guilty. Just fucking throw you in jail, right?
No, that's if you're not guilty. If you are guilty, you don't waste the government's time.
Amazing. Okay, guys, new rule. All right, this is a really awesome innovation. I don't know why people didn't think about it. You only get a trial if you're not guilty.
Didn't say you only get a trial.
Okay, so then help me out.
I said quite clearly. I said if you are guilty, then you go ahead and just say that you are guilty and you go along with it. You do not.
Oh, great. All right, guys, new rule. If you're guilty, you admit to being guilty. I can't believe no one's ever thought of this.
I didn't say
all right, so what did you say?
It's what you do.
It's what you do
as a person.
It's what you do.
You do as a person.
Okay.
Not you waste the government's time.
Well, a lot of people, I don't know if you, this might shock you. A lot of people don't do that, including, by the way, Trump.
I know. And that's why we have a legal system that costs
millions
of dollars to deport one person.
Yeah, but that's like to protect your rights, you know, for the innocent people.
It's really not.
It's
I'm literally never going to get deported. It's really never going to happen.
So only if something affects you are you going to stand for it. What a pathetic excuse for an American you are.
Not necessarily.
Not necessarily? You don't give a shit about anyone but myself.
You said it was me. It's affect my rights, but it's not. It's not actually ever going to affect me.
Due process.
Not my right.
Hang on a second. Do you think you'll ever be charged for a crime? It's possible that you might be charged for a crime wrongly?
It may possibly happen.
Yeah, so do you think the due process clause matters then?
It depends on
what
kind of case it is.
Depends if it affects me or not.
You're talking about a criminal case, I take it probably, and you're talking about.
Wait a second. So, do you think that you shouldn't deserve? Like, if the government tries to like take your property, you don't think you should have your day in civil court, even if it's not a crime? You think you should be like, oh yeah, we take your property, we find that you're delinquent on your rent payments, and the government's just going to take it as landowner or some shit like that. And you're like, wait, I've paid all my rent to the, I don't know if the government's your landlord or something, or if they have some kind of stake, or they're trying to do an eminent domain action. You don't think that you have due process rights associated with your civil rights, not just the criminal proceedings?
I think I do in a lot of cases.
Yeah,
not in all cases.
Yeah, you do. So stop with this whole due process only applies with oh, you don't think
there's a whole lot of things where due process is in tatters at the very best. And obviously, we're looking at things like
thanks to people like Trump. Wait, thanks to people like Trump.
Not even. There's a whole lot of people that are involved in this, where the whole country is involved in a lot of these things. The whole lot of different areas of the law. You know that there's a whole lot of different areas of the law. You got areas where you got things like a guy just down here scammed me on whatever Craigslist or whatever. And maybe
you got scammed on Craigslist?
Well, maybe you did, maybe you didn't. Eventually, I got my money back. So I mean, but should
what'd you get scammed for?
I was just buying some little computer part or something. I don't remember. Some memory or something. I don't remember.
So they scammed you out of a computer part, and that's why you think the due process clause doesn't matter, and so fuck it.
No, I think that's one of many, many, many areas that for him he would have needed maybe due process. But then what you end up with is that his due process stopped me from even being able to take much of an action. against him.
What are you
legally.
talking about? Of course you could take an action. Why couldn't you take an action?
No, but I have to take a civil action instead of the guys down at the actual courthouse, down at the actual police station coming and taking an action
Yeah,
against
because
him
they probably don't
he's
give
gonna
a
have a
shit.
whole lot of
They don't
right,
give a shit about
exactly.
you being
Because they-
scammed. I mean,
right,
that's
exactly. Right.
that
That's
doesn't mean you don't
bottom
have due
line.
process. That just means they don't care.
I mean, it's him that needed due process, not me. And you know, if I got due process in that situation,
Yeah, and if they charge him, I would definitely want, especially if you're alleging it, I would want him to have due process to make sure that what you're saying is an honest rendition of what actually occurred.
right, and these kind of protections and all, they stop all the minor things from being taken care of. And you say it's because they don't care. It's not actually technically true. I talked to the actual police officer there. He actually did care. He would have liked to take an action. It's the guys above him who are saying, no. It's going to be a whole big thing, and we just don't prosecute them because it's just not enough. It costs too much, basically, is what it is. It's not that they don't care. He'd be happy to come and bring that guy in, but that's not.
Don't be naive.
Exactly what's going to be able to happen.
They sent a stooge to fucking assuage you and be like, "Yeah, everything's
Not
okay."
at all,
And rub.
not at
They sent
all.
someone to rub your belly. They sent someone to rub your belly,
They
and you're
didn't
like,
send
"Oh, he
anybody,
was so."
First of all, I talked to him on the phone.
Yeah, and he rubbed your
He's
belly.
just a nice everyday guy. He's just a down home guy.
Sorry, my
And
boss
he
is.
says,
Oh, they telling me I can't do this. Click. Oh, you hear that guy? That's what they're fucking
Not
like.
even Click.
They didn't give a
Not
fuck.
Click.
They didn't give a fuck.
He would have been happy to sit there and talk all day. He got all the time in the world. You're just lying.
Okay,
You
you
don't know
all
what to
right,
do.
fine. You got a nice cop, but the higher ups who actually matter and who actually start investigations, they didn't give a fuck.
Right.
So what difference does it
It's
make?
not that they don't give a fuck.
Yeah,
It's
yeah, you
that
might as
it
well have
costs
talked-
too much. It
Yeah.
costs too much because we got people wasting motherfuckers' time.
Because you got murders happening and you have fucking crimes that actually matter happening.
And I agree. I actually agree with you on that part. I do understand what you're talking about. I agree with you. But even those kind of things, it takes super long time, super lot of money, all those kind of things.
Long money?
Yes, long time and a lot of money.
I never heard that one. And all this means that people who are proposed to be removed from the country shouldn't get due process? Explain that one to me.
I still didn't say that. You keep
all right.
trying to put it in my mouth, and I still didn't say that.
All right, then, like, what's your point? If you were like, kind of like, due process, whatever. You just want to waste time.
My
Like,
point
yeah,
is that he's just wasting time. Right. So it's just wasting time. It's literally all this is just wasting time. All that big paper that you read through, all of us discussing this, it's literally all just a waste of time. And, like you just said, he's still going to get deported. And it's just all a big waste of time.
I mean, I don't know. I feel like the people who are wasting time is the administration in their decision to like not comport with basic due process. And if they had, they would have wasted a lot less time, and there would have been a lot cleaner of a situation. Including, by the way,
you may be right about that, but let's think about this for a second, though. Let's just think about what happened for all the other guys that got deported with him, right? So they managed to deport however many of them it was. I believe I saw, actually, when the guy got deported, maybe 80 other guys with him or something there right around that time.
it was hundreds
So they
of people.
actually did get the other 80 deported, and it was quickly, and as far as I know, nobody else has any.
As far as you know. What are you talking about?
Well, I mean,
a lot of those people have like genuine claims of asylum. Some have been brought back to like and refouled to like Venezuela, and they've not been heard from again because they've probably been fucking killed.
Okay, so some of them didn't make it.
Yeah, that's
But
called
some of them did make
that's
it
a.
back.
Do you have like basic morality? Do you care about the government doing illegal things that causes the death of human beings?
If you're asking me about, like, do I care about whether or not the government has made an obscure clerical error or whatever, and that the Trump administration is going a little overzealous in actually deporting people that needed to be deported, the answer is quite literally no.
Yeah, you don't give a shit about other people. So what you call like
It's not giving a shit about other people. That's the lefty line. I am myself a defected lefty. I do give a shit about other people. It doesn't mean that I'm just gonna be like, okay, we now have to give everybody protections from just everything, and it's got to be protections, and you just can't ever be hurt. That's not what it is. It's a higher bar. It
Right.
sets a higher bar. It's not that you don't
But the
care
bar,
about things.
but the bar is the
Higher
government.
bar.
But the bar is the government's, right? I mean, the government is the one that needs to make the allegations, sustain them in a neutral arbiter, with a neutral arbiter, and actually follow the rules it sets for itself, right? It sets its rules in some cases, right? And it's not even complying with it. Like, you guys are government bootlicking shills. You just lick the boot of the government and you believe whatever the government says, and you're like, oh my God, the big problem is wasting the government's time. Guess what? That's the government's burden. It seems like all you want to do
I'm
is...
actually literally
Yeah.
having a conflict with the government right now. I'm not going to
Oh,
go
yeah?
into the details.
You don't have to go...
literally am. So
Yeah,
I mean,
so
you saying
then
that
you
I'm
should relate.
passionate-
So you should relate. Why are you being a bootlicking
Yeah.
shill and just being like, yeah, the government should be able to do everything it wants all the time. It should never be inconvenienced.
I didn't say that. I didn't say
Okay,
it
it
should
seems
never
like,
be
it's what you're
inconvenienced.
suggesting. Is it?
It's if you have a legitimate complaint. If you have a legitimate complaint, then make the legitimate complaint.
Okay,
Fine.
but providing due process and these protections is how we determine who has and
It's
who does not
one
have a
mechanism.
legitimate...
It's one mechanism.
What's
Just
the other
hold on.
mechanism? What's the other mechanism?
There's a whole lot of mechanisms there. You got the law, you got the courts, you got the
Yeah.
actual.
Well, hang on a second.
have
Wait.
to go out
Can
and
you
do
pause?
these
Can you
things.
pause?
You have
Pause.
budget.
Pause.
Go ahead.
How does the law protect you if you can't invoke it in any way?
First of all, it has a prophylactic effect, so to speak. That is, most governments aren't going to bother with
Not
doing
this
something
government.
against the
This
law.
government admitted that it facially violated the law, and it admitted that. So that might be
You
true for
keep
some other
saying that.
governments.
I missed where that was, and that I would
On this,
appreciate if you can
on the,
refresh my memory.
on the exact case we're talking about, on the Kilmar case.
Right, but how? How did that exactly happen? If you can just refresh me, just
Yeah,
in a
sure.
couple of sentences.
Yeah. So the rendition, the deportation to El Salvador, violated the statutes on withholding of removal, and additionally, removing someone without an order of removal, alternatively, you might say, and without due process of law. So that, and the government acknowledges that it sent someone to a country that it was specifically ordered not to send that person. And by the way, it's not the only time it's happened. There was one recently that happened recently. Like, so they like very obviously don't give a shit about the law, and the prophylactic effect of the law doesn't have much purchase in this administration.
I mean,
You need
say that.
you need a
but the
forum
fact of
to
the matter
invoke
is,
you.
He actually does obey 99.999% of court orders without even so much as blinking.
Oh, that's so naive. But I will say, you just the broader point. You need a forum to invoke the law. The law by itself, it's like a right. You know, like the Soviet Union had rights.
I'm familiar with it. I know
Yeah.
what you're talking about, and I understand.
You need a place to like make your case. Because if you just like, oh, the law will save you, the law won't save you unless people respect and
I
follow
didn't
the
say
law.
just the law will save you. I didn't say that.
Okay,
It
but that's
has-
the
it's
law.
one
The law.
mechanism.
The
It's
law.
one mechanism.
The law plus due process. That's where you're going to get the vindication of your rights. If you don't have due process, then the government can just like arbitrarily do whatever it wants.
Well, so you allege, but in real life, it just doesn't happen to work out that way, which is obviously inconvenient for your point. But you want to think that it's some kind of where you really got to have that, and you really got to have that, you really got to have that. In real life, nobody here in my neighborhood is ever going to get deported right here. In this little neighborhood, it's not going to happen. It's literally not going to happen. So, I mean, all these people right here.
Do you
are
only care about
100%
your?
completely.
Do you only care
No,
about your little
I didn't
neighborhood?
say that I only care
Okay,
about my neighborhood.
so the reason
You
I
keep putting
no,
things
hang on
in
a
my
second.
mouth
Okay, wait
that
a
I
second.
didn't
So
say.
we're gonna just get things clear, okay? When you say, well, no one I know is gonna get deported, no one in my neighborhood. When you do that, it seems to suggest that is a sufficient condition for you not to care about something. Now you're suggesting that it's not a sufficient condition. Then I ask, why do you invoke
I didn't say
it?
it's not,
Okay,
not
so-
sufficient to not care about it.
So
you're gonna
I'll
care
ask,
about
is it sufficient or
about
not?
less.
Is it sufficient or not?
You're going to care about it less.
Okay, you care about it less, but I'm trying to give you reasons why you should care about the due process clause,
I appreciate
and
you doing that, and I do.
more broadly than just the people who are proposed being like deported, because they'll always start with people that you don't like or people who you feel like have a less deserving right than you do.
So
That's
some
how they
people
start.
always say. So some people always say, because they think that Nazis are around every bush, but Nazis are not actually around.
No,
every
not
bush.
stop
Trump is
it.
just a New York liberal.
Don't do this.
and
Don't do
that's all
this.
it is.
Don't do this. I mean, you really think that like it's not just a Nazi thing? It's they will go after weaker groups first, and sooner or later you look around and like, where are your rights? Wait, what is it
You
like?
say they, but there's a lady downtown who is the mayor of Charlotte. I live in Charlotte right now, by the way. She is the mayor of Charlotte. She ain't going after anybody. She's not going after fuck all of anybody. Like you're saying they're going to go after the weak groups and all this stuff. The dude that's in the governorship of Charlotte, he ain't going after anybody. Even if they put the Republican in there, he ain't going after anybody. Maybe some criminals of this, that, and the third, but in general, the mayor is not after any of them.
Are you serious, bro? Aren't you the guys that are supposed to be like pissed off about COVID and all the like fucked up lawfare the government's doing? You're telling me like, oh, don't worry about that. The government will never infringe your rights. They'll never go after people.
I didn't say don't worry about it. I didn't say they're never going to. I said that right now.
I think you literally said they're not gonna. Yeah.
That specific person and the other specific person that I mentioned, they're just not doing it. You're acting like there's just people that are just like out to get us. They're out to get us, you guys. They're out to get us. They're not. They're not out to get you. They're not out to get you, Pisco. They're not out to get almost certainly 99.9% of the people listening right now. They literally don't give two shits about 99.9% of the people listening right now, and in the country, for that matter. They literally don't care about them at all. You're saying that they're out to get them. They're not. They're not out to get them.
So what I'm trying to tell you is the erosion of due process rights implicates all of us. And for your own sake,
I understand theoretically. I get it.
What do you mean theoretically? No, not theoretically. Practically, like this is something that every one of us has some interaction with. Some benefit provided by the government, some restriction imposed by the government, some kind of penalty applied to certain conduct. We all have friends or family who interface or have been, accused of things improperly, or who have not been protected, or who should be protected, or something has gone wrong, or maybe even disputes between like a contract dispute between two private parties, where you're relying on there being a place to vindicate what you're entitled to as a matter of both, the law of the respective jurisdiction or whatever the norms are in the broader level. So like you claim as though like this is all, or the way, I'm not saying you explicitly say this, but the way that you kind of talk about it, you seem to suggest that it's like a hermetically sealed thing, and that one erosion of due process need not affect all of our lives. What I'm telling you is that these overreaches, they have a tendency to be related, and even now in the current administration, it's like a whole of government effort to promote its its views and its its policies, even going so far as to like try to overwhelm states' rights. Even like recently this whole stuff about the gerrymander in Indiana, they're like threatening Indiana. They're like trying to like withhold funds from California for the wildfires. And so all of this stuff and Trump's arguments here, it's not just about the immigrants. It's about the fundamental. Let me just finish. Let me finish. I'll let you respond.
Go ahead.
I'll let you respond. It's about us as individuals. It's about us as we relate to each others. It's about the array of our society vis-a-vis the states and the federal government. It's all about all of it's included, and to limit it just to immigration, I think is myopic. It's not really how the Trump administration sees itself, and it's not really how these rights will cash out.
All right, I appreciate your critique there, and I do understand what you're saying. You're, at least from that perspective, you're saying that, all right, he's wanting to try to get more power, basically, is what you're saying, and then he's going to use that power to do things that you don't like, or possibly that the whole country doesn't like.
Well, that much is obvious. I mean, the whole country doesn't like the tariffs. He's, overwhelmingly in terms of the polling. I'm not saying that there aren't some people who like the tariffs. There will always be like winners and losers on particular tariffs or whatever, and people who are made better off. But by and large, the people are not liking what he's doing as a policy matter. And a lot of what he's doing is legally dubious at best, including and especially the tariffs. Like Congress has the power to tariff, and that's imposing real costs on the cost of living. And he's going around saying it's a fucking hoax. Inflation doesn't exist. Cost of living, it's a democratic hoax. And so, yeah, I do think that he will try to usurp authorities to try to do things that are fucking unpopular. And not only do I think it will happen, I think it already has.
Right. I hear you. I understand what you're saying. Yeah, and I'd be happy to go over the things on the tariffs and all some other time or whatever. But the thing that I'm just saying, just for my own self here, I just don't think that we can say these teeny little inconveniences here that are where, especially it's where you're just literally just wasting people's time and money and saying, well, this is due process, and if this is overcome by the Trump administration and or ignored by the courts, or the courts don't uphold it, courts don't enforce it, courts don't make sure that you have these protections in all cases and what have you, then just, we're going to be at the absolute mercy of whoever the administration is, in this case, the Trump administration.
Yeah.
I just don't buy that. I just don't buy
What do you mean you don't buy it? Like, do you think that just because something's inconvenient? It's a question. I'm not saying you said it. All right. So don't fucking get triggered. Just because something's inconvenient, like a right, like to give a trial, that we should say like we don't care about whether it was given or not, or you wouldn't, even if it were a murderer, right? Let's say a murderer didn't get a trial, and he's obviously guilty. Would you stand up and be like, that's wrong? You guys should give him a trial. Would you do that? Yes or no? You can answer that.
I mean, for a murder, I would probably just remain seated and say that that's wrong. But
yeah, it doesn't really feel like you value American values. Then it seems like you're okay with the government just doing things and not having to check on its power.
I would say it is wrong. I just said that I would say it is wrong. I'm just not going to be all up and
yeah. Why wouldn't you stand up? I mean, because presumably someone who's principled and cares about these freedoms would say, "Hey, we know this guy's guilty, but we have to do it the right way. And the reason we do it the right way is because we don't want to make exceptions for these important protections. Because once we make an exception like this and we say, oh, he's so obviously guilty."
No, I'm not saying make an exception. I'm not saying that. I just said that it would be wrong. I'm saying no.
No, you wouldn't stand up and be like, hey, no, you got to give him a trial. You wouldn't protest and be like, the government needs to give this murderer a trial. It's the right thing to do. You wouldn't do that?
I think in your mind, you're coming up with a hypothetical where the government is absolutely denying him the right to a trial and is about to throw him in jail or execute him or something, and so we need to actually stand up and go and march and tell the government that immediately he must have his trial. I mean, there's plenty of time for the trial in real life. It's not something that has to have happened immediately. We don't want to let it go for too long. Justice delayed, justice denied, and all that.
No, but you're just like, I don't know. You're like, oh, we don't have to worry about it too fast. We don't have to guard it very... It's not an important issue because someone will work it out. That seems to be the attitude that I'm hearing from you.
Yeah, I'm not going to lie to you. Like, just to be 100% honest with you, like a lot of the things...
Oh, you're a troll. Wait a second. Do you know how to work Discord? Why do you have a fucking server tag? It's fucking...
Not troll, bro.
I'm
halfway boomered. I have to have my hand held.
No. You have a server tag. So you've heard of Discord before, you fucking liar. This is
I've never heard of it.
Why do you have a server tag, you piece
server.
of shit? No. What is that?
I'm Jessu's server.
What's
They're
that?
DJs. They're DJs.
They're DJs? Jessu?
Yeah.
Who's Jessu?
You can put her name in the search tag in Twitch and find her channel. You can put PYKA. She's on right now. A DJ. You can.
Yeah, but if you know enough to have a server tag, you're a troll. And listen, I'll give you the last word. Yeah. Go. You can have the last word. What do you want to say?
I'm literally not trolling. I have trouble with Discord, and also you have like a way.
You said like what is? You said what is Discord? Didn't you say what is Discord?
You're right about that. No. I had actually. I meant what Discord is it? Sorry, I had a typo in that because I was trying to join. Yeah. Sorry.
Oh my god, you motherfuckers! All right, what did you want to say?
I don't remember. I mean, maybe we just wrap it up. It's all good. I appreciate you. I appreciate the chat.
Hey, I'll just ask you. Hey, listen. I hope you had a good day. But I will say, I don't think you should be okay with like the government violating due process, even if you think like it'll get worked out eventually. Like we just gotta be like very sensitive to this shit and police it very hard, because once we stop doing that and we're like, oh, eventually something will happen. Like if we start to lose that connection. I think we lose a little bit about what makes our society worth protecting. And I don't want to turn into fucking China, where we're like, there's no trials and shit, and people just like get disappeared by the government.
Which I agree with you on. I understand. I just have to say that I just don't have the zeal for it. Maybe I'm too old. You might be younger than me. I don't know. Maybe I'm just too old. I don't have the zeal for like defending
For your
everybody.
rights, for your rights, for the rights of your
I'm sorry.
like the people who come after you. Isn't that like? Don't you have some pride in the Constitution and the society that
Bro,
you're a part of?
I do, but I believe that it takes a long time to work these things out, and it a lot of times does take a long time to work these things out. It's not something that I want to get my blood pressure up over or whatever have you.
Yeah.
It's not something that I want to like cause myself physical upset over. Again, I don't have the vigor of youth right now,
Uh
so
huh. Well, listen, I appreciate you calling in. Maybe we can chat again sometime in the future. All right.
all right, man. I appreciate you.
All right.
Have you a good one.
Appreciate it. Later, bro. Bye. I can't tell somebody. I mean, these guys are good trolls, man. If it's he said, "What is Discord?" and then he has a fucking server tag. I'm like, if you have a server tag, you know Discord, all right? You know Discord. That's Lauren Southern's sister. Curiouser and curiouser. Oh, her older sister. Wait, okay. Wait, what? And then who's the PK? Someone DJs. All right, Michael is getting his underpants. What happened? Trump did something. Is it the Colorado woman? Let's see if we can. The guy seemed genuine. I can't tell these days. I really can't tell. Is this some fucking Tim Pool shit? Oh no, he's trying to pardon Tina Peters. I mean, just understand. He can pardon her for like federal offenses, but he can't for state offenses. So you know, I wouldn't be too worried. Now, if there's some development, he tries to fucking send troops into the Colorado prison, we can talk. Okay, if he's genuine though, it's like, how do you he's just kind of like, oh, you know, yeah, you should have a trial, whatever, if you're a criminal, but you know, I'm not gonna do anything about it. Or I'll say it's bad, but I won't actually try to defend it. Is Colorado governor Dem or Rep? A Dem, but I have my own issues with him. He's like a RFK apologist. Jared Polis. I think it's him. What up, folks? Do we have any other individuals? Probably not. Oh, real quick. Luigi shit. Right, guys. You want some Luigi memes? This is a good meme. This is a spicy little meme. Now I don't know where the court is going to land on this. I think Luigi has the better of arguments on one thing. Like, I think Luigi's argument on one of these is very, very strong. And it actually relates to a case I'm quite familiar with. Hang on, let me show it to you. This is some... Can you imagine if they fuck up that prosecution? That would be nuts. That would be fucking nuts. Okay. So, Luigi... shout out Luigi. Listen, I condemn violence. I think that they should put this guy away. I am not in supporter of Luigi at all. All right? Let me just do my little liberal surrender hands. My pre-apology on Luigi. Common good is Luigi defender. That's sick. That's sick. I'm serious. Sick. Don't defend Luigi. But maybe we have some prosecution fuck ups. And so there's a as part of their motion to dismiss, they included additionally a motion to suppress evidence. And it's like a classic, like law school exam question. They've been doing a lot of fuck ups, including the perp walk, Eric Adams and his little outfit. I just can't stand these people in their little outfits doing little fucking cute little media appearances with their little outfits. And Eric Adams with his bullshit. Can't stand it. Anyway, so this one I think is like a strong Mangione argument. The tougher one is what comes after it. So it's a suppression motion. For folks who aren't aware, one of these vaunted constitutional protections is the freedom from unreasonable searches and seizures. It's the Fourth Amendment. And a search, okay? Actually, oftentimes there can be some disagreement about what constitutes a search. I think the best way of analyzing it is kind of too bifurcated about what a search is. You can take the leading case of Katz, Katz, which has this like reasonable expectation of privacy analysis about whether you're intruding into a reasonable expectation of privacy. And then additionally, you have these kind of like constitutionally demarcated areas that have protection regardless of the reasonable expectation of privacy. And so those are things that like constitute a search. So going and looking at someone's house, even assuming there were a time in which there wasn't a reasonable expectation of privacy with your house, let's say that it becomes ubiquitous to have like infrared cameras everywhere and to have like glasses that you could like see through people's houses, that certain principles of constitutional protection apply even beyond this Katz doctrine of reasonable expectation of privacy. So you can think of like the core areas, houses, papers, persons, and effects. And you can think of the reasonable expectation of privacy as like a gloss there, okay? As like an additional tests that are kind of getting into the same thing, but also distinct. And there you can see overlap in the motivation for reasonable expectation of privacy applying to your houses, papers, persons, and effects, but extending differently. But not all searches are unreasonable. It's the Fourth Amendment protection is specifically for unreasonable searches and seizures. And what makes something an unreasonable search and seizure is a subject of a lot of debate, obviously. The word reason and reasonable is a very subjective. Unlike Ryan Mullally, I don't happen to believe that God wrote on my heart the answer to all the questions of reasonable searches, okay? Reasonable minds can disagree about what constitutes reasonable searches and seizures. But there are some kind of like known areas. So the default is a search is unreasonable if it's not pursuant to a search warrant, except when a valid exception to the warrant requirement applies. Things like exigent circumstances, okay? Things like, plain view. Things like consent, all right? These are all established exceptions to the warrant requirement of the Fourth Amendment, all right? The Fourth Amendment, which applies to both state and federal officers through state officers directly via the Fourth Amendment, and then as incorporated with the 14th Amendment as applied to federal officers. Remember, the Bill of Rights initially only applied to federal action. I might have gotten that reversed. To states through 4th and 14th, and through the federal with the 4th. Got it? And so, we have the Fourth Amendment, we have what a search is, intrusions into constitutionally protected areas, or intrusions into someone's reasonable expectation of privacy. There's additional doctrines that are beyond the scope of this little review, right? Things like the third party doctrine. If you their bank records are not necessarily if you're handing them over, things that you post on social media, etc. There's a very interesting case. It might be called Carpenter, about cell phone location data, where I think on a narrow margin that was found to be a search. Could be wrong about that. But there's a bunch of side doctrines that we're not going into. We have the presumption that a search is unreasonable if not made pursuant to a search warrant, and then additionally the exceptions that at some point start to swallow the rule, right? There's the vehicle exception, and there's the airport like exception in these border areas where you're even though the Fourth Amendment applies, there's an exception both to probable cause and to the warrant requirement. And by the way, a warrant needs to have probable cause to back it, that a crime, that there's going to be evidence of a crime or that criminal activity is afoot, you know? So there are exceptions both to the warrant requirement and sometimes even the probable cause requirement. Consent is another example of that. If you consent to a search, it doesn't matter if they have either a warrant or probable cause. You've consented. But there's a great deal of swallowing of the general rule with the various different exceptions. Okay. Enter Luigi Mangione. Okay? Luigi Mangione, one of the exceptions, I'll start with that first, to the warrant requirement is a search incident to arrest. They can search you when they arrest you. Okay? And that is an exception to the warrant requirement. You don't need to get a separate warrant for a search incident to arrest. But there's a very specific set of criteria for a search incident to arrest. Otherwise, you can understand the potential for potential abuses. Right? You have somebody who you have probable cause for an arrest, but you choose to arrest them when they've arrived at home or something, so that you can do your kind of warrant exception for the search. You have probable cause to arrest, but you don't have probable cause to search, let's say, right? Their residence. So you arrest them right when they arrive, and then you claim the exception. So there's a set of case law that limits it a little bit. Which brings us to Luigi. Luigi had a backpack, and in the backpack there was evidence. And now let's read. The Altoona law enforcement, this is, by the way, the brief of Luigi. They haven't decided it yet. Failed to follow fundamental Fourth Amendment case law and basic police procedure by failing to obtain a search warrant before searching through Mr. Mangione's backpack and the closed containers within the backpack. So imagine, right? Luigi Mangione captured, and they rifle through his backpack, okay? Clearly a search, all right? Going through someone's effects, that is about as search as you can search. Not only is there a reasonable expectation of privacy, it's one of those constitutionally enumerated areas. It's your papers and effects, right? That you're carrying along with you. And what I think is strong for Mangione is the search incident to arrest analysis. But I'll mention why potentially there's a big problem in it about what they're trying to do. Police conducted this warrantless search of the backpack, even though there was no exigent circumstances, as Mr. Mangione was already in handcuffs. The backpack was on a table over 6 feet away, and Mangione was separated from the table by a wall of armed officers. And then they go into these cases I talked about, cats, right? I never found out if it was Kymel or Kimmel versus California. This is the case that's most famous for establishing the search incident to arrest exception. And it's no wonder that Mangione's lawyers lead with this, in addition to Katz, which is, over and again, this court has emphasized the mandate of the Fourth Amendment requires adherence to judicial process, and that the searches are per se unreasonable, subject only to a few specifically established and well-delineated exceptions. One recognized exception to the warrant requirement is a search conducted by a law enforcement incident to a lawful arrest. In Kimmel, or Kymel, depends on who you are, the Supreme Court set out the rationale and limitations for a search incident to arrest. And the two qualifications are basically officer safety. Those are the two rationales: officer safety and destruction of evidence. So you're allowed to do a search incident to arrest to effectuate the purpose of the arrest, which would be frustrated if you weren't allowed to, search the arrestee for contraband that he has in their pockets or evidence of the crime itself on him that he might destroy while he's being taken to the jail or something. Likewise, what if he has a knife stashed in there? This would frustrate the purpose of the arrest. And so for those kind of dual purposes, we allow you to search their person, and this matters. Their immediate, where does it say? Let's see. And look at the examples used. In addition, it is entirely reasonable for the arresting officer to search for and seize any evidence on the arrestee's person in order to prevent its concealment or destruction, and the area into which an arrestee might reach in order to grab a weapon or evidentiary items must, of course, be governed by a like rule. So you have this kind of like on their person in their immediate grabbing zone. A lot of grabbers out there. So their immediate zone of control or grabbing, however you want. So a lot of references in these cases about like their immediate zone to grab something or to control something. And in Kimmel, the search here went far beyond the petitioner's person and the area from which he might have obtained either a weapon or something that could be used as evidence. So as I recall, Kimmel, they went to his house. They had some allegation that it was like that he had some contraband or some stolen goods or something like that, or that he was like a bookkeeper, he was running. It might have been that he was running like a gambling thing, and he was like a bookie or something. Someone looked that up. Kimmel versus California. I think he was like a bookie, and like they went to arrest him in his home, and they go search through the drawers and like search incident to arrest. Right? And so they found like, okay, you went way beyond it. You were like looking for shit beyond his person. You went to his home, and then you got started rifling through shit. All right. 4 years later in Arizona v. Gant, also a very important case in the Supreme Court, the Supreme Court again explained Kimmel Court's rationale for limiting searches incident to a lawful arrest to only the arrestee's person and the area within his immediate control. In Kimmel, we held that a search incident to arrest may include only the arrestee's person and the area within his immediate control, construing that phrase to mean the area from which he might gain possession of a weapon or destructible evidence. Right? So you have those two roles there: officer safety, police safety, and evidence concealment / destruction. See also U.S. v. Chadwick. The search was conducted more than an hour after federal agents had gained exclusive control of the Foot Locker and long after the respondents were securely in custody. The search therefore cannot be viewed as incidental to the arrest or as justified by any other exigency. So you can imagine there could be a case in which, all right, you're not the thing is outside. You're not a grabber anymore. It's not like you can grab the bag, but you have independent evidence that there's an exigency. For example, you have reason to believe there's a bomb in the bag or something like that, right? Well, now the search there is justified by something else. It's justified by an exigency. So if there's a self-standing exception to the warrant requirement and probable cause for something else or for officer safety purposes, yeah, you can go beyond that. But then you don't need the arrest there. You could just always do that, right? You don't need the arrest. Likewise, if you really feel, and if there's a plausible basis to believe that the community's in danger, you don't need to get a warrant before you enter a place where you think someone's life's at risk or something. You're wrong. He was a late night host. Was he? A late night host? Wasn't he a bookie or something? And we have some examples in U.S. v. Gorski. The FBI arrested the defendant and his co-conspirator at a bus station as part of a drug sting. When the defendant was stopped, he was carrying a black vinyl bag. And this is from the Second Circuit. And that's applicable. I think this is a federal case, actually. Maybe there's a state analog case. I'm not sure. But there's definitely a federal proceeding here. An agent took the black bag from the defendant, who was then frisked and arrested in the presence of several. So this might be binding precedent on whatever. Where is this? Is this in page 28? So this is in the SDNY. Okay, cool. Yeah, because he was shot in Manhattan, I think. Relying on limitations set by SCOTUS for search incidents. Oh, wait, we already read that. Oh, this Second Circuit case where they had a defendant, they had the bag, they frisked the guy, right? They search incident to arrested him and then arrested him, right? And then the bag was somewhere else, and then they didn't get a warrant to open the bag, and they found the kilo of cocaine. See, someone like the previous caller would say, this is all stupid. We know he's guilty. In finding the search not justified as a search incident to a lawful arrest, the district court made the following ruling. The bag belonged to the conspirator. It was turned over to the defendant. At the scene of the arrest, it had been taken from the defendant. Both defendants were placed under arrest and handcuffed, and the bag was placed on the ground, all in the presence of several agents, all of whom had their guns drawn. The bag was thus not accessible to either defendant. It was not mobile in the sense that the bag was going nowhere other than the agents to the federal building, and with the agents to the federal building. There was neither a risk of defendant getting to a weapon in the bag, nor a risk of defendant destroying or absconding with evidence from the bag. Though the government argues the search was lawful as incident to the arrest, presumably a security procedure, that claim cannot stand. The facts at the time of the search suggest no exigency in the form of risk either of harm or to the agents or loss of evidence. Agreeing with the district court's analysis, Second Circuit noted the warrantless search was not justified by exigent circumstances since the bag was inaccessible to the suspected drug dealers and there was not the slightest danger that the luggage could have been removed before a valid search warrant could be obtained. And so all this is to say, I think the case law here is somewhat strong. That given the time difference, given the fact that the guy was arrested, and the bag was like kind of in like a different area outside of his control, I don't think you could justify that search based on it being incident to arrest. And I don't think that there's any other exception that applies. The typical rule is exclusion of the evidence. So the danger here is that the prosecutors could lose whatever they found in the bag. And that's what the defense is arguing for, is suppression. But there is this other doctrine called the inevitable discovery doctrine. And that's where I think there could be some issues. Like if it's the case that they would have discovered the evidence no matter what, then sometimes they don't have to exclude all the evidence or whatever. And the defense kind of preempts the argument here, which is, well, we would have found this anyway subject to an inventory search, which is another exception to the warrant requirement. And they can establish that the evidence would have been uncovered in an inventory search. And they have their reasons for why it wouldn't be, and certain more limited precedent about the requirements for a valid inventory search, getting rid of a problem of like a bag situation, right? And here they said this case, Mendez, that the government has legitimate custody of the property being searched so that an inventory search would have been justified, that when the police and the police agency in question conducted the inventory searches, they did so pursuant to established or standardized procedures, and that those inventory procedures would have inevitably led to the discovery of the challenged evidence. And basically what they're arguing here is you didn't go by procedure. And because you didn't go by procedure, you can't claim inventory search because the procedure here is to get a warrant. And like we talked to people and that's what they said. And so you didn't follow the procedure, even assuming you could fulfill the other two requirements, the first and third of Mendez. And so that's the kind of fear here, is you might lose the bag. Now, will that mean that you lose the case? I'm not sure. And I'm not really up to date on these, on this specific litigation. But it just goes to show you the importance of all this shit and of the cops and lawyers doing things the right way. Not just because they might lose the evidence in this particular case, because it matters to us. Like these rights, what good would the Fourth Amendment be if there was never any punishment for or bad effect if the government violated it, right? The whole purpose, presumably, of having these amendments is to prevent harms done when they're infringed, or to have some way to vindicate them. And if you limit the ways in which that can be done, you start to lose more and more the reason why we even have these protections in the first place. And so even in a case like Mangione, where I think it's a justified case and where the guy, he should be going to jail, this is totally unjustified by killing. To me, it is alarming, frankly. Who does the Trump administration have working this case? Who is actually leading it? And is it... I mean, this is police conduct, to be clear. I'm not saying necessarily that it's the DOJ, but it's, ultimately, at this point, I'm just going to apply. And did the killing happen on Trump's watch, or did it happen on Biden's? When did the Luigi Mangione killing? No. When did he kill? Oh, never mind. Under Biden. Okay, well, I'll say the following. You know what, Biden? You fucked this one up. If we're going by the Trump standard, it's on Biden. Obviously, tongue in cheek. We shouldn't apply that just because the bad thing happens under the presidency that it's them. So I'll give it to them. And then that particular aspect of it, we can. And these were local police anyway. Fuck it. But yeah, just keep an eye on that shit. I think it would be pretty fucked up. Pretty fucked up if he went free, and I don't know what the response would be if like they found him innocent or some shit. It was in December 2024. Okay, guys. Yeah, I think that Lonerbox and I will discuss it. I'm gonna message him. We can talk about it tomorrow. This has to be a fake AI image of Trump using a walker. Totally AI. God, no one can ever fool me. AI will never fool me. Copium. I think we're good. I think tomorrow we're gonna talk to Hutch about. I think I'm still gonna be here probably for tomorrow. I'll probably go back to New York and Saturday. But we'll talk to Hutch and Lonerbox. Hutch about Ethan Klein, Lonerbox about seizure of the tanker, and additionally the H3 stuff as well. I'm gonna push that. But I love you guys very much. You guys are the best. Thank you for the support. Keep liking shit. Keep liking the channel. Bit of a rebrand. I don't know if you realized it, but it's just Pisco now. It's cleaner. You may have noticed. But love you guys very much. We're still working on perfecting the overlay for my usual setup, so that all the chats are displaying, including the YouTube chat, but that we comply with Twitch's rules. But I appreciate you guys viewing, and thank you so much for the membership, Ian Weatherford. Check your super chat. Oh, how do I do that? Can't see it. Can't see it on this in my current state. I'll look when I can see it. All right, I'll be able to find it. I'll save you the time. The tanker seizure was theft. The U.S. didn't have jurisdiction or rights to take it. It's an act of aggression that could spark war. I mean, yeah, I'm against it. There's nothing that I want to hear less than you and Hutch talk about Ethan. Just focus on the tanker. I know, but that's what we're doing. Thank you for bringing the fight. Thank you all. Thank you for super chat. Boars. And sorry, I missed yours, Ian. Apologies. And thank you for the memberships. If you get memberships, you get access to the emotes. You get all the good stuff. So appreciate it. And more to come on all fronts. We're growing. We're becoming better. Everything's good. And really do appreciate your guys' continued support. Stay cool. See you tomorrow. Hutch, Lonerbox, Tanker, H3, Lawsuit, Denims, Hassan, Piker. I condemn it all. Now ban debate for. It's Pisco. It's cleaner. And he gets to be a lawyer. What a sick joke.